Wait, please. Wait, please, your lordship.
Yes.
Well, I filed this appeal on Saturday, my lord. I have challenged the order of the learned single judge in dismissing my writ petition, whereby I have challenged the order of transfer. The relieving order has already been issued. So if your lordship can kindly take up this matter tomorrow, my lord.
I will get it listed tomorrow. Right.
Lordship, I beg to mention item number 20, Lordship.
Yes.
Lordship, in this matter, my senior is out of station, Lordship.
You are appearing for the petitioner appellant.
Appellant, Lordship.
Then counsel Mr. So-and-so submits that arguing counsel Mr. So-and-so is not available. Who is not available today?
Mr. R.P. Kakote, Lordship.
R.P. Kakote is not available today. And thus a prayer is made to adjourn the matter. The other side has no objection. List after 2 weeks.
Bless, Lordship.
Yes.
Numbers 23 to 34.
May I please, your lordship? I beg to mention item number 25, lordship.
25, yes.
This matter may be adjourned for today, lordship.
And counsel for the appellant. Praise for time. List after 1 week.
May it reach your lordship. My lord, with the consent from the other side, my lord, I pray for item number 27 to be adjourned for 2 weeks, my lord, and may be fixed on the 22, my lord, 22 of May.
Then counsel, you are for the
my
appellant
lord.
state.
My lord,
I am as so-and-so. Praise for time. The other side has no objection. List on 22nd May.
obliged.
May I please, your lordship?
Yes.
Lordship, I beg to mention item number 32, your lordship.
Yes. 33.
32, your lordship.
Yes.
Lordship, the petitioner has passed away on 27th of April, your lordship.
So it has become infectious then.
Nothing survived. Your lordship.
Then counsel, Mr. Ahmed submits that as the petitioner has passed away, the cause of action does not survive in this writ petition. Hence, the same may be closed, ordered accordingly.
Lordship, I beg to mention item number 47.
Yes.
In this matter also, Lordship, my senior, Mr. R.P. Kakote, is out of station, Lordship.
Same order.
Lordships, my prayer is if a date may be fixed.
Date, you can have it in second week of June. Give any date in second week of June. Maybe 8th or 9th June.
Right.
May please, your lordship. Lordship, with the concern of the other side, lordship, I beg to mention item number 58, your lordship. I am for the
58.
respondent here, lordship. And there's some instructions are still awaited, your lordship.
And counsel Mr. So-and-so submit, but he requires some time to complete his instructions. List after 2 weeks.
Much obliged, lordship.
Item number 1 of daily list for orders.
Right? Let's see.
May I please, lordship? Lordship, this I was filed for paper publication, lordship, and I have filed my affidavit, lordship. And last order 23, 2023, that has been shown in the order,
Yes.
lordship.
Mm.
So LCR has been received.
LCR is received.
Matter may fix for hearing, lordship.
All right. The service has been effected on the respondent, but nobody has put in appearance on her behalf. LCR has been received. The appeal is admitted. List for hearing in due course.
Much obliged.
The IA is disposed of. List the appeal for hearing in due course. Is this true? Okay.
Much obliged.
Yes.
Item number 2.
My lord, in this case,
If your lordship would kindly have a look at order dated 10/9/2020, my lord.
10/9/2020.
Yes, my lord. While issuing notice, para 5 and 6.
Just hold.
Till that, my lord, the affidavit has not been filed.
Joint written affidavit.
Yes, my lord.
What is the controversy?
Para 5, my lord, of order dated.
All right, what is the controversy? Can you let us know?
Controversy is, my lord, this is regarding land acquisition for widening of the national highway.
Okay,
My lord, widespread corruption, my lord. My lord, we have brought on materials also before.
widespread.
I mean, irregularities.
Okay.
Leading to, my lord, misappropriation of, my lord, the person whose land has been acquired, they haven't got money. Whereas person who doesn't have land, he have got, my lord, money. The CEM's wife got, my lord, 4 crore on the very first day when money is released.
Chief executive.
Yes, members, wife. Please come to para 5 of that order, my lord.
Yes, yes.
We having heard Sri so and so at some length and having considered the serious nature of the acquisitions, including the allegations that the real landowners who are large in numbers have not received any compensation, whereas influential persons have been given compensation without their land having been acquired.
Really
Direct
serious.
respondent 1, 2, 3 to file one joint written statement, which is required to be parawise. We further direct secretary to the Hill Department of Hill Areas Government of Assam, dispute to take instruction and record from various authorities and file his personal affidavit, which is also required to be parawise. Till that, my lord, this affidavit has not.
The response numbers 1, 2, and 3.
These are the government authorities, my lord.
Union of India.
One is Union of India.
So NHAI
Yes,
and general manager, you are representing. Where is the affidavit?
I have filed it.
No, my lord, basically, my lord, it was Hill Areas Department who was to file the affidavit. my
But
lord.
this direction is to 1, 2, and 3, Mr.
No, my lord, the later part of para 5, my lord.
Para 5.
We further direct
The
secretary of the department Hill Areas.
What
That
is the
respondent
kind of
number 4.
NHAI must have given the money to the LAO. The dispersal is
No,
by
my
the
lord,
at the local level.
As far as my lord NHCI is concerned, there may not be much of a role. End of
Naturally.
the day, they place the money at the disposal
To the
of the
LAO,
state
LAO,
authorities.
LAO.
It is the state authorities who does the mischief, my lord.
Who is the land acquisition officer in this
There
case?
is a officer of the rank of my lord joint secretary. Huh?
My lord,
Who represents?
I'm appearing on behalf of the competent authority for land acquisition appointed by the central government, my lord.
Mhm.
And we have filed the affidavit. I have received the status of the, my lord, acquisition of the land. Land acquisition proceeding has already been completed. Amount received from the NIGDCL has already been disbursed. Only certain
Whom? That is a question.
the beneficiaries, my lord, we have already filed the affidavit that all the beneficiaries whose names were published by in the central government. in
Where is
Gazette
the
of
where is
India.
the affidavit of the Secretary Hill Council?
Yes, that is the most important.
My lord, that is the-
Secretary Department of Hill Areas.
Yes.
Who represents number 4, respond number 4. Despite pertinent direction given by this court, by the order dated 10/9/2020, comma, the respond number 4, Secretary to Department of Hill Areas, affidavit on behalf of the respond number 4, Secretary, Department of Hill Areas, has not been filed. MS M. Bhattacharjee, Government Council, to ensure that affidavit, detailed affidavit on behalf of such affidavit, such respondent is filed positively by the next date of listing. Re-notify on 7th June, 7th June.
Deeply.
What is the IA about?
My lord, I have filed by the ask, my lord.
For what
For
purpose?
my lord, my lord, lordship's issued a direction to publish the notification, my lord.
Hmm.
And they have published the notification in the name of the Chief Justice, my lord. So we want to bring it to the notice of the court.
Notification.
By the public notice, they have published in the newspaper in the name of the Chief Justice, my lord. So we have want to bring it to the notice of the court that.
Who has published it?
My lord, petitioner, my lord.
Me?
Yes, sir.
Where is that notification? Where is that notice?
Which is there?
My
Summon.
lord. Yes, my lord. Lordship will look into it, my lord.
Annexure 1.
Annexure 1, my lord.
Where is it? SD. Oh, they have just referred to the order as such.
If it is done, my lord, is a definitely error, my lord, that will be withdrawn.
Page 11.
Page 11, my lord.
How could the summon refer to the names of honorable judges?
Name of the, my lord, it cannot be, my lord. They have, my lord. If you lordship look into the notice, my lord, they have published.
In
it
any
like-
event, the summon has been served.
My lord, my lord.
So you file an apology, Mr.
My lord, certainly,
Chaudhary.
it was by mistake.
Yes. I will remain.
Item number 3,
My lord, we have replied their affidavit. And how they are making a statement that they had evicted the Ankusar. It is never. Lordship, kindly see my affidavit.
Beg to interrupt, Lord.
Let me, madam, make the submission first. Because they are taking adjournments for last 4 years, they did not evict. None of the Ankusars were evicted.
They did not evict.
Evict.
Whom?
That my lord, the Ankusars. I have given the names here. Lordship,
Ambushers,
Ankusars and the PIL.
encroachers.
Ankusars. The PL, my lord, the Honorable High Court directed them,
Hmm.
and they have given an undertaking. That
Yes.
is evict such and such persons. Lordship, kindly see, my lord. I am drawing with Lordship attention to annexure in my affidavit, Lordship.
Where is the order, sir? Where is the order?
Affidavit, Lordship. At annexure
Where is the order? What is the order? Let us see the order first.
of the Honorable Division Bench. In the-
Yes,
In the PIL.
yes.
Lordship, yes, the PL is at contempt case 420. Lordship, PL, judgment is at page 11 on the contempt case, my lord.
The respondents will take steps as indicated in para 3 of the affidavit in opposition filed by the respondent number 2.
My lord.
What is the stand?
Lordship, before proceeding to the merit of the case, I like to point out, Lordship, and respondent was newly pleaded in the case. And I suppose notices have not been served today.
Newly impleted.
Respondent number 4, Lordship.
Okay. But respondent number 3 is there. Direction is to.
I am there.
So
Lordship.
the direction, respondent number 3.
Yes,
Yes,
I
he
can
can-
proceed,
he can-
Lordship. I have just pointed it out.
It's okay. What is the respondent number 3? Let us know. Has done.
Lordship,
Yes.
if your Lordship.
Who is the respondent number 2? The direction is to the all the respondents. That includes the respondent number 3 also.
Lordship, if your Lordship may advert to page 41,
Yes.
that is the minutes of the SDLAC meeting in which the land has been allotted for the purpose of a children's park, Lordship.
Yes.
If your Lordship may peruse resolution number 30 at page 43, Lordship.
Hmm.
Allotment of land measuring 5 bighas, 2 kothas, covered by dark number so and so under Ulubari Moja in favor of Guwahati Metropolitan Development Authority for establishment of children's park
Hmm.
is approved as per order dated 26/8/2019, passed by Honorable Guwahati High Court in PIL 70/2018.
Hmm.
Assam Society versus so and so. The
Okay.
construction of the park is to be given.
Oh, that's all right. That's nothing but a paper direction. What has happened? What is the situation on ground?
On ground, Lordship, the handover of the land has been handed over to GMDA and they have given a letter to the respondent number 3.
What is the
stating that-
physical status of the land? How many encroachers are still there on the land, sir?
Lordship, as regards encroachment, if your Lordship may please refer to the order which was passed in the PIL,
Yes.
the paragraph number 3, Lordship, page 13.
Yes. Page 13.
Yes, page 13
Yes.
is the order, page 14 is the relevant part, Roman
Yes.
2, Lordship.
Yes.
The due eviction proceedings is under process against encroacher Gopal Mondal against his unauthorized encroachment of a part of government land
Hmm.
covered by doc number 370. This is the encroacher number 1, Lordship, Gopal Mondal.
Hmm.
Roman 3, that due eviction proceedings are under process against the Arjo Vidyapit Higher Secondary and Bahumukhi Vidyalaya,
Yes.
as the said institution has been found unauthorizedly encroaching a part of land by erecting pakka pillar. Now, as regards the directions, Lordship, Mr. So and so.
What has happened finally to the eviction proceedings, sir?
Lordship, I have issued eviction notices to all of them.
In this order was passed in 2020.
But subsequently, Lordship, a review petition was preferred, which was disposed of after 1.5 years or 2 years or like. After that, the eviction.
Where is the order under review?
The order under review will be at Lordship, page 47. Effective order starts from page 50, Lordship.
Review was filed by
The
those
review-
encroachers.
Lordship, the review was filed by the college authorities
Okay.
that they needed land for ingress and egress, Lordship.
Reasonable passage be given, exact location will be
Lordship,
done by so and so.
Lordship.
So after that, what has happened?
After that, Lordship, the passage has been given to the college and eviction notices have been issued for the rest of the land.
Where are those notices?
The Lordship, the notices are at page 39, page 38, Lordship.
You referred to page 70, come to page 70. You say that Gopal Mandal has filed a writ petition. But whether there is any stay,
No, Lordship, but it mentions that the
There is no
interim
stay order.
relief shall be considered on the next date. And the college authorities have again preferred a writ petition in which there is a stay, Lordship.
What?
where are those stay orders?
I am furnishing it, Lordship.
That interim relief was to be considered on 25th January. Now we are in May.
Lordship,
That order at page 75 says prayer for interim relief will be considered on 25th January.
Lordship.
Now we are in May.
Lordship, it got listed once, it was left over.
So there is no stay as on date. Proceed.
Lordship, there is a single bench case which is pending. That is the reason why.
Mere pendency of the case without there being any stay. When there is a direction of the division bench to evict him,
Lordship, the one writ petition has also been preferred by the college authority.
let us see that writ
in which there
petition.
is a stay which has been granted. The first writ petition is listed today, Lordship, as per information just now given to me.
Hmm. So
Now,
in
Lordship,
division bench, you took a stand that it is an encroachment.
Lordship,
So where is the question of trying to find out whether it is allotted or not?
no,
The order reads that no eviction should be done of the petitioner from any land which has been duly allotted to it. You
Lordship,
gave a
I'm-
categoric version in the division bench that it is an encroachment, plain and simple.
Lordship, if I may please point out, what is the need of the demarcation? The map which shows the land and the physical possession.
Hmm.
There is a mismatch between the two. That is the reason why in my affidavit in opposition, I have mentioned that a resurvey with the director of land records shall be required. If your lordship produces the trace map,
Hmm.
I will. be
But
able
what
to
is
show-
the difficulty for you to complete that process?
Lordship, the boundaries as per trace map and the boundaries as per physical possession does not match.
Para 7 of the order you have passed on to this court says eviction, no eviction should be done from land duly allotted. Before any such drive is undertaken, there has to be a proper demarcation. Then why did you give an affidavit here in division bench saying that this is purely an encroachment?
Lordship, the resurvey problem, when the eviction steps were taken, it came to our notice then. If your lordship perishes the trace map which has been submitted, I am showing the mismatch.
Who's there for the college authorities? There's no one representing them here.
So they
In
are
the
not the
contempt,
parties
they
here.
will not. What does this indicate?
Lordship, the lordship will note that there are three big.
Oh, all right. How much time do you need to complete this resurvey process? We give you 7 days time. Complete it.
Lordship, it will be very short a time.
Why? Is it something called rocket science or what?
No.
So physical measurement is to be done. Now you have all those facilities of geo mapping.
Lordship, if the dark numbers are not matching, I have to renumber, I have to do the entire exercise.
Oh, this is just nothing but a means to provide them a way to ensure their encroachment.
No, no.
To affirm
Lordship,
their
this is a
encroachment,
genuine
that's all.
problem.
All right, you keep your deputy commissioner present in the court on the next date. We'll ask him then.
Lordship.
Yes.
If your lordship may peruse the order which has been willfully alleged to be violated.
Yeah.
The order will be at page lordship 11.
Read para page 14 of the order under contempt, sir.
Yes, lordship, page 14, it says.
Para second, Roman second.
Roman second.
Yes.
The due eviction proceedings is under process against the encroacher, against his unauthorized encroachment of a part of government land. Similarly, the Roman 3, due eviction proceedings are under
Complete that
process.
para, sir. Complete para second.
The due eviction proceedings is under process against encroacher Gopal Mondal against his unauthorized encroachment of a part of government land
Yes.
covered by doc number 370.
So this is your affirmative version in division bench,
Lordship,
that there is an encroachment.
Lordship.
And para second, para third,
The due eviction proceedings are under process against the Arya Vidyapith Higher Secondary and Bahumukhi Vidyalaya as the said institution has been found unauthorizedly encroaching a part of government land of the said dog by erecting pakka pillar with iron pipe nearby.
again, a clear stand of the authorities that there is encroachment.
Yes.
Now, why this variation?
Lordship, but what I have been directed to do, Mr. So-and-so has submitted that the government is taking necessary steps to evict the encroachers.
Yes.
And by following the procedure, land will be duly reserved for the children park. Lordship, how much land? It is at page 13. Page 13, the fourth paragraph says, Lordship, this PIL was filed by a society which is a registered NGO along with 11 citizens. The case projected by them is in a nutshell is that there is a plot of land measuring more than 5 bighas covered by 3 dogs. So Lordship, 5 bighas, 2 kothas encroachment free land has already been allotted and has already been handed over. So as regards the children's park, there is no difficulty on the ground. But in addition to that, there were directions for evicting 2 encroachers.
Yes.
For that, we have taken steps, Lordship, and they have taken legal remedy. So we are apprehensive that in where the legal remedy has not been disposed of, if I go to take any action, that might be contemptuous.
What do you say, sir?
Or the other.
Yes. We can't just forfeit the right of the concerned litigant to approach the court for enforcing his legal rights. They say that 5 bighas have already been reserved. There is no counter from your side. What do you say?
My lord, if they evict the encroachers, my case is. Well,
Sir, your case is that 5 bighas of land, you came out with the story that 5 bighas of land is encroached. They have released that land. It has been handed over to GMDA.
my lord, they did not evict the encroachers. And
Read the
then
order, sir.
My lord, there was no direction from the honorable court.
Read the order.
My lord, yes.
What is the direction?
My lord, kindly, my lord, see.
The prayer was very categoric, 5 bighas.
More than 5 bighas, more than 5 bighas.
Yes.
Mr. D. Soikia, page number 14, my lord.
Yes.
Mr. Soikia has submitted that the government is taking necessary steps to evict the encroachers, and by following the procedure, land will be duly reserved for the children park, and thereafter the plot will be converted to children park.
Yes.
It is how they can convert it unless they evict them.
5 bighas they have already done, sir. 5 bighas and how much?
My lord,
5 bighas, 2 kothas.
my lord, they did not evict anybody of them. I kindly see my affidavits. I have
All
given the photo also. None of, because they are giving indulgence to the encroachers and asking them go to the court and file with petition. This is the spirit of the deputy commissioner. Lordship, kindly see my affidavit at page 83. This is the counter affidavit. They themselves issued the notice. Page 83, my lord, annexure 1. Taking over land by GMDA for establishing a children park. With reference to subject cited above, I have the honor to inform you that the land of near Ajjavidut College at Ajjanagar measuring 5 bighas 2 kotha covered by dung number 370, 381, 382 of Ulibari under Moja so and so has been taken over by GMDA from district administration today on 13 December 22. On the said plan, GMDA has already started preliminary work for the establishment of a children park. Next page, Lordship, kindly see. Next page, my lord. How they wanted to avoid. Page annexure 2. Principal Ajjavidut College regarding encroachment of land hearing number 81. With reference to the subject cited above, I am to inform you that you are occupying a portion of the land measuring to government Act number 381 of Sawar Ulibari Guha, part 3 under Ulibari.
All right, we are taking the writ petition here. We'll call both the records here and then we'll decide. All right.
Lordship, may I? Lordship, the writ petition 7775 of 2022 Gopal Mandal is listed today before court number 3.
That
Okay.
is for impleadment. I have filed a petition for impleadment.
All right, you get impleaded and plead before the court that there is a direction for eviction.
My lord,
Because if we call that writ petition here, their right of appeal goes.
my lord, while there the order with division bench, honorable division bench to evict
Sir,
them.
the division bench, your case was Now they are disputed questions. Willful disobedience, they say that we have reserved 5 bighas for children
Five
park.
bigger two kotha.
Yes, so
He, Malad, it is she, Malad, kindly see that they themselves admitted that annexure 2 of my affidavit. That you are, Gopal, Adjunct College, you are occupying a portion of the land belonging to.
understood, sir, but now that litigant has gone to the court, got a stay, what can they do?
No, they did not get any stay order, what's it, in the single bench.
Lordship,
No, that is allotted land. Which land is allotted? This land was never allotted to them. But if it is allotted to them, then this stay will prevail. Land was never allotted to them.
Lordship, there is another petition number WPC 729 of 2023.
That is what the order has been given to us.
Yes, your Lordship.
Yes.
That is also your Lordship.
Let those writ petitions be disposed of, then we'll see. And Government Council has pointed out that the 2 respondents in this writ petition for whose lands the direction was given for eviction, eviction in the category of encroachers, have filed writ petitions before learned single bench which are pending consideration. The matter is this adjourned by 4 weeks, awaiting outcome of those writ petitions. Number likh lena.
Madam, may I pray, your lordship, during the pendency of these cases, they are, madam, again, art filling, Adjunct College. They should be restrained, madam.
Where is that? Where is that affidavit that they are filling there?
We have filed this affidavit.
What have you mentioned? Read.
Yes, madam, kindly see, my lord. Lordship. Lordship, paragraph 4
What have you
of
said?
my counter affidavit. That is statement made in paragraph 5 of the additional affidavit. That is, GMD has already started preliminary work is not correct. At all.
In the meantime, the authorities concerned shall ensure
My lord,
that no activity of earth filling shall be allowed in the dark numbers in question. That is 381.
Doc number 381.
381, dark number 381. All right. List up 4 weeks.
Obliged.
Letter number 4.
Substitution petition.
My lord, as per the,
Substitution petition was to be filed.
my lord, there was some difficulty in confirming the addresses, my lord. I have filed it today only, my lord.
Then counsel, Mr. Your good name,
B Pathak, my lord.
the Pathak submits that he has filed the application for substitution in terms of the direction given by order dated 13/2/2023. Today, the said application shall be processed and listed for orders after 1 week.
Give me that.
Letter number 5.
This is a matrimonial appeal, my lord, appeal preferred by the husband.
Mhm.
And record is called for, record is before your lordship, my lord.
You want record to be summoned?
My lord,
The judgment is on what was your,
no, my lord, I am not challenging the, that divorce, my lord. I am
Then-
only on the permanent alimony point, my lord. In the point of permanent alimony, my lord, they have not, only in one para, they have disposed it without considering any evidence, my lord.
who is there for the other side?
I'm for the respondent.
You are for the respondent. So we'll call the record and then hear the matter.
Yes, sir.
Let record be summoned from the lower court. It's here,
Yes, my lord.
argue.
Not today, my lord, fix a hearing date, my lord.
We'll admit it then.
My lord,
The appeal is admitted, record has been received, lists for hearing
must.
Let me be fixed, your lordship.
in July, 2nd, 3rd week of July.
Obliged.
Letter number 6.
What is the IE for in this case? This is a separate one. Okay. 6. Yes. What is the IE, sir?
I have filed for continuing a delay of 7 days, my lord.
No one has appeared.
No, my lord.
The connected appeal, connected MAT appeal is delayed by how many days?
7 days, my lord.
7 days.
Yes.
Service of notice has been effected on the respondent in this interlocutory application filed under section 5 of the Limitation Act seeking condonation of the delay. No one has put in appearance on behalf of such respondent. Thus, considering the grounds set out in the application to be germane, comma, the delay is unknown, interlocutory application is allowed. List, the corrected appeal shall be numbered and listed for admission. Deeply.
Number 7 to 10.
My lords may kindly finish the last order, my lord. In fact, this is the third PIL alleging same irregularities, my lord. First PIL was disposed of by this honorable court. Second PIL, my lord, may kindly peruse the order dated 27/3. In the second PIL, my lord, when it was apprised before the honorable court, there are vigilance inquiries going on. That was closed. Immediately thereafter, within a month, my lord, this third PIL has been filed. So by the last order, my lord directed me to, my lord, take instruction regarding the status of the vigilance inquiry.
Preliminary inquiry.
I have received- It is ongoing, my lord, it's not yet completed.
May I please, your lordship?
Just. Why it is taking so long, sir?
My lord, the order was of, my lord, February 27, my lord,
February 27th of this year.
of this year, my lord. to cause
Okay.
an inquiry, my lord.
That was passed in this Anguri Nava Nirman
Yes,
Samiti.
my lord, PL 82 of 2021. Before that, my lord, earlier occasion also, my lord, another PL was filed. Then this honorable court, my lord, directed to approach the honorable governor, my lord, chancellor of the
All right.
university.
What do you say, sir?
Lordship, I'm sorry to say, Lordship, but the additional advocate general is misleading the court, Lordship. In all the petitions, PILs that have been filed, Lordship, none of my cases have been referred to. Those are not their, Lordship. These are.
This is a different set of allegations as per you.
Different set of allegations, totally different, Lordship. And Lordship 82, last occasion, Lordship had said that PIL 82. That record should be brought, what has happened, Lordship. I have gone through it, Lordship. Not a whisper of my.
Your allegations are different as per you.
Totally different, Lordship. Totally different, Lordship.
What do you
In
say,
that-
sir?
In that case, Lordship, some 3 or 4 universities were taken together and a case was filed, Lordship.
Okay, okay.
But as I have seen, my lord, from the PILs, my lord, firstly, my lord, irregularities of the university and some service matters are alleged, my lord, regarding anomalies in giving some promotions, appointments, my lord. If my lord peruses PL 3 and 5 prayer portion, my lord, absolutely on service matter, PL 3 and 5, item number 9 and 10, my lord.
Service matter related.
Law is settled, my lord, in service matter,
In-
there cannot be any PL, my lord.
There can't be, yes.
PL 3, my lord, peruses.
PIL 3,
In
let's
fact,
see.
to that effect, I have filed an affidavit, my lord, raising maintainability issue, my lord.
PIL 3, let's see. Prayer. Is he an employee?
No, my lord, he is a politician, my lord.
Not a politician, Lordship. How can he say that Lord, he is not a member of any party, Lordship?
My lord, in page 66,
Lordship,
PL number
What
3,
is happening?
prayer number 1.
Hold on, sir, hold on.
Lordship, Lordship. Sorry, Lordship.
We can't
Sorry.
keep on entertaining petition, PILs right, left and center. Yes, read the prayers.
Page 66.
Selections, appointments, promotions.
Exactly. my
How
lord.
this is a subject matter of PIL?
Prayer number 2, my lord, prayer number 2, page 67.
Yes, yes, yes.
Illegal orders of appointment, promotions of faculties of university. To direct the respondent authority of government more to inquiry as how funds were being provided by the government of Assam.
Which is the court monitored inquiry commission they are referring to?
They are praying for, my lord.
No. Read para 2.
Prayer 2, my lord.
Finding of the above referred court monitored inquiry commission. Which is the inquiry commission you are referring to?
Not so, we
He's
we
asking
require,
for
we
a
are
prayer-
asking
Prayer
for.
number
Lordship.
1, my lord,
We
inquiry
are
commission
asking
is
for,
prayed for. Prayer number 2, the consequential partners.
To constitute a court monitoring inquiry commission.
Lots.
Why?
Lordship, what is happening, Lordship? In different cases, Lordship, issues are like this, Lordship. They are giving, Lordship, Lordship knows, Lordship, that professors serve up to a period of 65 years, Lordship. That has been extended, Lordship. They are giving it to the statutory officers also, Lordship. 65 years they are making. They are not entitled to, Lordship. Where from the fund they are utilizing, Lordship. Government fund, Lordship. That should not have been done, Lordship. One of the allegations, Lordship. Then, Lordship, may I go one by one, Lordship? One by one. Which one is, Lordship?
All right, you choose which you are arguing first. You select.
Lordship, number 2 is with me, Lordship.
PIL number 1. First we have PIL number 1. Let's see what is
Lordship.
the allegation. Illegal creation of teaching departments.
Lordship. Lordship, for creation of teaching department, Lordship, there should be, Lordship, approval from the Chancellor, Lordship. That is the Honorable
Governor.
Governor, Lordship. That was not there, Lordship. That was not there, Lordship. Without that approval, Lordship, they had been opening colleges, Lordship, two colleges, Lordship. Then, Lordship, there have been some teachers have been appointed, Lordship, without the sanction of the, without the knowledge, in fact, without the knowledge of the Governor, Lordship, Honorable Governor. How can that have been done, Lordship?
All right, we'll issue notice to all the respondents.
Lordship,
Extensive hearing is required.
Lordship, extensive hearing is required.
All right, issue notice to the heard. Land Council, Mr. Bhagwati submits that the subject matter of these four PILs is entirely different and has no concurrence oblique conflict with the amendments made in the PIL number 82/2021. Full stop. The preliminary inquiry which is being made in pursuance of the directions given in the said PIL is in reference to entirely different set of allegations. In view of the facts noted above, let notice be issued to all the respondents.
Lordship.
Mr. Goswami appears for
I am appearing for respondent 1, 2, 3, 4, 5, 6, 7, man.
for the response numbers 1 to 7. Thus, let process be issued upon requisites being furnished, process be issued to the remaining respondents. Rule is made returnable in 6 weeks.
Number 11.
Yes.
Lordship, this habeas corpus was filed because the authority has not gone through the rule 4 of the Bengal Public Demands Recovery Act 1913. My Lordship, on the last occasion, it was I had mentioned that it was not served to the adult male member as per this rule. Actually, they served it to the woman actually.
Yes.
So the notices has been served actually.
Yes, Talukdar.
Corporation department appearing.
Yes. So where is Mr. Nath was also supposed to appear?
The standing council corporation department, he will appear. Lord.
For all the respondents. So where he is, Mr. Talukdar. Mr. Talukdar is the standing council.
Yes, Lord.
Where is he?
The last order also, he was directed to appear.
So where is he, madam?
In a last order, my lord, the honorable court has directed the standing council, Mr. Talukdar, to give a copy, my lord. In fact, here for the respondent, Mr. Talukdar appears for the Bakija officer of the cooperation department.
So we have also given him the notice.
Yes,
Where is he?
but kindly take up.
We'll pass it over right now for
Yes,
the time.
Just I'll
Let him come.
Yes, I will.
Item number 12.
Review.
May I please, your lordship, my lord,
Yes.
I beg to pray for a short adjournment of 10 days, my lord. Some difficulties, my lord, on my
All right.
part, my lord.
You are Mr. Bhuyan,
My lord, they are Bhuya, my lord.
Mr. A.R. Bhuyan, Land Council representing the review petitioner. Praise for time.
My lord,
List. Up to 2 weeks.
my lord. Oblige.
Review applicant कर दीजिए.
Item number 13.
The IA is for confirmation of delay of 349 days in.
How many days?
349 days, my lord.
349
Yes,
days.
my lord, paragraph 10 is the cause of delay, my lord. There is a pending review petition, my lord.
Okay.
Paragraph number 10.
Where is the order? Passed on review.
Well, review dismiss, my lord, not annexed, my lord, the review order.
Review order is on
I have-
14/2/2013.
Yes.
23. What do you say to condonation?
My lord, in clause, paragraph 10, my lord,
Hmm.
the whole 343 days not explained properly. Otherwise, I leave it to your lordship.
The review was disposed of on 14/2/23
My lord,
and this appeal was filed on what date?
my lord.
15/3, my lord.
15/3. So that is, all right, this interlocutory application has been filed by the petitioner, appellant seeking condonation of a delay of 343 days occasion in filing of the connected appeal. It is stated in para 10 of the application that a review petition was filed, review petition number 22/22 was filed seeking review of the order under challenge dated 2/2/2022, which was decided on 14/2/2023. The time the delay is thus occasioned on account of pendency of the review application. No formal application, no formal opposition has been filed to the prayer for review. Having considered the submissions advanced at bar and treating the grounds set out in the review application to be germane, the prayer for condonation is accepted, the application is allowed. The connected rate appeal shall be numbered and listed for admission.
Highly obliged.
Obliged.
Number 14.
No one. None present. List after 1 week.
The number 15.
Yes. Shh, take care. What is the IA?
My lord, there is a delay in preparing the appeal of 39 days, my lord.
What do you say? Delay,
39
Mr. Comment Advocate?
We have no objection.
No objection. The connected rate appeal is delayed by 39 days. The appellants have filed in the instant interlocutory application seeking condonation of delay. Appellant condition. Occasion in filing of the appeal. Done it. But there are private respondents also. Notice has to go. Issue notice. Mr. So and so, your good name, please.
NC Khatunir, my lord.
NC Katniar appears for the response numbers 1 to 6.
1, 2, 3, and 5, 6, my lord.
For 4
I am appearing. And thus.
appearance लगा दीजिएगा and 10 सबका हाजिरी लगा दीजिएगा. Thus, on requisites being furnished, notices be issued to the response numbers 7 and 8. Rule is made returnable in 3 weeks.
Obliged.
Number 16.
Lordship, this IA has been filed seeking extension of time, Lordship, to act as per order of this.
What is the order?
Lordship, the order was first to open the seal cover and consider the promotion of the writ petitioner
Mm,
to the post of senior editor, Lordship. 1 month time was given, Lordship.
mm.
We seek 3 months time at the time of filing of the this application. That is on March, Lordship. Now, Lordship, 1 month time will be.
Now this already 4 months time has passed,
Lordship.
or 3.5 months at
1 month
least.
will be sufficient. Lordship.
What do you say?
My lord, order was passed on 25/1/23.
Like they are assuring that they will do it in 1 month.
Yes.
These matters, they do take time.
Yes.
Even the meetings are not convened very frequently. So we'll grant them time of 30 days from today.
Lordship, my lord.
The IA number so and so has been filed seeking extension of time granted by this court by the order dated so and so, passed in so and so, to consider the case of the respondent for promotion
Yes, Lordship.
by convening the DPC. First up, then comment council, CGSC, Mr. so and so submits that the process for considering the case of the respondent has already been started and that it will be completed within next 30 days. In view of the submission so made, the respondents are granted further opportunity of 30 days from today and shall complete the process in terms of this court's directions positively by 12th June. The interlocutory application is disposed of accordingly.
Oblige.
We'll take it thereafter. Supplementary बीच में मत लाइए. Unless there are motion, yes, we'll after. Before hearing, you follow out supplementary.
Number 17.
Well, by order. Yes.
May it please your lordships. Lordship, the petitioner herein is a designated senior advocate of this honorable court, and the cause espoused in the instant PIL is with regard to the right to health of the citizens of the state. My lord, if I may take your lordships to page number 23 of the writ petition, my lord.
Yes. They're all newspaper reportings, madam.
My lord, I will try to satisfy your lordships on that issue, my lord. My lord, if I may just read out the bottom column, the 4 institutions asked to test fish samples in state. Now, my lord, why this particular 4 institutions have been asked to test the fish samples in the state is because the Nagaon District College had carried out a research for a period of 3 months by collecting fish from 10 different local markets. Now, in the said report, my lord, whatever findings have been found are enunciated in this particular news report, my lord. If I may read, my lord. Following a study by Nagaon College that detected harmful chemicals in imported fish, the State Fisheries Department has asked 4 institutions, that is Guwahati University, Raha College of Fisheries.
That is why it is very advisable to go vegan.
My lord, my lord, there is one aspect to this, my lord.
Yes. No, it's serious. That was on light vein. We'll issue notice to the respondents. This affects
In the
a
meantime,
major population of the state. Yes.
there is one more prayer, my lord.
Yes.
So, my lord, these 4 institutions are going to undertake a particular exercise of testing the fish samples from different areas. Now, my lord, after finding out the report, if in case the report comes out in the positive, just as it has come out in the case of Nagaon College, my lord, in the meantime, hundreds and hundreds of trucks of fish from different states will enter the state. And as per the report,
They
of
must be
Nagaon
bringing
College-
them under certain contracts, under certain permits. Those are not the scope of the PIL. If it is a general order, then the state has to take a call.
My lord, the fisheries minister.
Every individual truck cannot be checked for the level of arsenic or formaldehyde.
The fisheries.
Madam, do you know that the water which Guwahati is drinking contains high content of iron? Is it right? Can we direct the state government to stop the flow of water?
No, my lord, but my only concern is, my lord, this formaldehyde has already been found in, as per the Nagaon College report, and the quantity is more than 50%.
Your case is based purely on newspaper reports, madam.
My lord,
Let the state
Nagaon
respond.
College has been made a party.
Notice. Requisites. Who are the parties?
My lord, the first 3 are the state, and the respondent number 4 is the Nagaon College. And
So-
our prayer is that your lordship may call for the report from the Nagaon College.
State will bring, let Nagaon College be.
Nagaon
So,
College is a party.
it's a pro forma respondent otherwise.
Yes, my lord,
MSM
because
Bhattacharya puts in appearance on behalf of all respondents,
Lordship.
all 3 respondents. Nagaon College is also a government college. Perhaps you can take instructions. She also assured that she'll take instructions to appear on behalf of the respondent 4 as well. Response to the averments made in the PIL, the preliminary response to the averments made in the PIL be furnished within next 10 days. List on 22nd May.
my lord.
Extra sets of the
Yes, ma'am.
writ petition be supplied to MS Bhattacharya today itself.
My lord. Deeply
Number 18.
Sufficient copies. Yes.
I is for condemnation of delay. When an appeal is filed, perhaps notice fee room.
Why it's listed for admission then? If there is a delay, how can it be listed for admission? Okay. Original record.
I think it is our matter, Lordship.
Yeah. So you are still in the shock of the yesterday's loss or what?
It was very shocking, Lordship.
Yes.
Something.
This is interlocutory application for stay. What is the matter about?
Lordship, in this case,
Yes.
for two posts in Kachar district, two applications came. And all along the affidavit before.
All
the
right, now we recollect. Is that order?
That affidavit also the director filed when somebody else was.
That the
appearing at
records were,
earlier
not-
stage.
the applications were not forwarded even.
Yes, that is not forwarded the main chunk, but two applications were received according to the affidavit which was filed before the learned single judge. Was those two applications belong to 2012, not of 2014.
Yes, that's what
And
you
that was
stated.
the agency who all along was saying that we have destroyed the thing. Now, when we entered after Lordship's interference in this case, now the records are coming to us. So I would like to.
What about those false statements, Mr. Saikia?
Absolutely, Lordship. How to deal with it, Lordship? That is very difficult. The director who was present the other day.
He has made a statement on record.
But the affidavit was filed by the earlier director.
It's really strange.
Now this E. Gramin, who was conducting the examination, they said that we have lost, we have destroyed
Destroyed the
everything. Lordship was very harsh on because Lordship indicated that what can happen to them. After 5 years, they said that we don't keep the records. Now records are coming.
So then,
So
can you identify or locate the two
Yes,
applications
two
of the
applications we have found. Those two applications were sent by post, not to the district authorities, but to the state director.
Place them on record?
Yes, Lordship.
We'll place them on record.
Yes.
All right. Mr. Saikia submits that though this court was given to understand on an earlier occasion that the original records pertaining to the selection process in question had been destroyed, but now he has been apprised that the original records are available and that he shall be placing on record the applications filed by the private respondents.
Yes.
As per Mr. Saikia, these applications were unrelated to the selection process in question. That's what your stand is. You said that they were of the year 2012.
Earlier, that was the statement. Now we have come, the date was given in 2014.
Okay, so he shall be placing on
I
record
place the original record. These are with me now.
the applications and the other relevant materials on record.
Lordship.
List after 1 week?
After 1 week. Lordship.
After 1 week.
So we have received a communication from E. Gramin also now.
No, this is.
Everything is coming out.
You need to digitize the records. That will resolve many things.
Now that the records are there, so Lordship will definitely have to come to a genuine conclusion now without any guesswork.
All right.
Highly obliged.
Number 19.
Lord, a particular works contract was given to the petitioner, my lord, which was terminated, my lord, number one, without notice, and the authority who terminated the contract, he had no authority.
Was not
Now,
competent.
No authority. There was no notice. Yes, there were some notices regarding how to progress the work, but there was no notice before termination. My lord, learned single judge dealt with both these issues in a manner, in my humble submission, is not correct. For example, as far as my lord, at page 133, regarding my lord termination by the executive engineer at page 133, para 24, as regards the contention raised on behalf of the petitioner on jurisdictional issue, namely that termination order was issued by the executive engineer, whereas authority chief engineer, the same is issue was subject matter of dispute in writ petition, namely so-and-so. Well, that is a case of PMGSY work. It's a building contract, my lord, doesn't apply, my lord. And nobody argued this matter, my lord. And neither the respondent nor we made any, argument on this aspect.
What is their response to your government in the writ petition? How do they respond?
No, my lord, our case is very simple, my lord.
Read your ground in the writ petition, please.
Yes, kindly come to my lord, page number 34.
Para 7.
Para 7.
And what is their answer to this?
Yes.
Where is the order? Can you please refer to that order?
Yes, my lord. Para 7, can I read at page 34, my lord?
That we already read.
Where is
the order?
Yes.
Where is the order?
57. Page 57, my lord. P57. The order is at my lord, page number 56. Now kindly see, my lord, it is the personal assistant to the CEM, my lord, who directed.
CM, CM.
CEM as chief executive member is like chief minister of that
Okay.
council, my lord. With reference to the subject cited above, I had been directed to draw your kind attention to the fact.
This is a direction by the CM to the executive engineer.
No, my lord, PA. Personal assistant to the CEM.
No. This letter reads, I have been directed. That means the PA was directed by the CM.
Yes.
The order signed by the governor.
Oh, okay.
By order of the governor.
Oh,
That's how
let
they
us
are.
take that also, but it is the executive, it is the additional chief engineer under the contract who is competent.
So this, as per you, the CM is not competent.
No, my lord, that I'll show, my lord. Please come to my lord, page number 77.
And where exactly is the termination order?
Yes. Termination order to go there. My lord, first, my lord, page number 51. It is by the executive engineer, page 50.
Action of authorities of
Yes.
NC Hills Autonomous Council.
He also refers to last reference, my lord. PA to CM NC Hill have written instruction dated 11/9/2020.
All right.
And page 77, please see, my lord. Employer, page 77.
Who is the employer?
Employer is the additional chief engineer, PWD Hills. And my lord, page number 82. Termination, clause 59, 59.1. Employer or contractor may terminate the contract if the other party causes fundamental breach of the contract. So employer is the additional chief engineer, it is the executive engineer who has done. And learned single judge, while deciding to relies upon a judgment which has got nothing to do with this, that is regarding PMGSY contract.
The term of the contract has not been considered even.
And secondly, my lord, there was no notice.
No notice.
No notice.
Where is that argument dealt with?
Yes. Page 34, my lord.
Para.
Yes.
The notice.
Yes.
Where is the
yes. Para 7,
consideration?
Yes. The para 7, fourth line, executive engineer PWD is not the competent authority to terminate. No, I'm saying. And before issuance of the letter dated 59/2020.
Where is this argument dealt with in the impugn order?
Yes. Page 133, my lord.
Para, sir. Paragraph.
Yes. 1 second. In so many words, my lord, this aspect has not been dealt with. The learned single judge starts from page 32, my lord, para 22.
Okay.
To examine the grounds of challenge and justification given, it would be necessary to note certain dates. Notice as so and so. Then para 23, court finds force in the argument of standing counsel. That
Yes.
pending is, my lord, in so many words, that aspect has not been dealt with.
Yes, please.
I'm appealing for a respondent and Hills Autonomous Council, Lordship. After the judgment of the single judge, Lordship, work order has been issued to the
Irrespective of that.
Lordship.
How can you justify a totally illegal decision? Who is the CM of the NC Hills to direct the termination of the contract?
No, not that.
No.
Lordship may kindly.
Where is the notice before termination?
Lordship may kindly.
There is what?
Page 113, Lordship.
Yes, read please.
Of the retaping, Lordship.
Yes.
The affidavit filed by respondent number 4 in writ petition, Lordship. That is
Additional chief engineer.
additional
Yes.
chief engineer.
Read.
Lordship, paragraph number 4. May I
Yes.
read, Lordship?
Hmm.
That the deponent begs to state that the petitioner was allotted the work for construction of S1000 Media Center at Haflong, Dima Hasao District under Dima Hasao Autonomous Territorial Council package in Dima Hasao District, Assam during the year.
Sir,
2000.
can we be specific, please? This para doesn't anywhere indicate who was competent to terminate the contract.
Lordship,
Where is that
Lordship,
answer to para 7 of their writ petition?
the said project was a centrally sponsored project, Lordship, and it was a time-bound project, Lordship.
Mr. Counsel, please don't beat about the bush.
Lordship.
Pertinent queries made. Where is the answer to para 7 of the writ petition?
Lordship, paragraph 6, Lordship.
Yes, read.
That the petitioner was negligent and slow in carrying out the work within the specified time. As a result of which the North Kachar Hills Autonomous Council was suffering loss. The respondent number 4 time and again reminded him to complete the work within the targeted time, but he was not
So
interested.
you
in
want
fi-
us to pass any observations against your NCL's CM or what?
No, Lordship.
Where is the justification answer to para 7, please? Will you read? The executive engineer not being competent, where is the answer? And no notice given. 2 questions, simple.
Lordship, notices were given to him, Lordship.
Termination of contract.
Lordship, regarding that, Lordship. Lordship may kindly peruse page 51, Lordship. Here it
Yes.
has been referenced that so-and-so notice has already been given, Lordship.
Let us see page 51.
51, Lordship.
Yes. Read which
Reference-
notice?
Administrative approval, so-and-so, letter of acceptance, this office, number so-and-so, minutes of the review meeting, Lordship, this office, all this is our notice, Lordship.
Notice for termination of contract.
Lordship,
Are we not very clear what we are asking you?
Lordship, I am clear, Lordship.
So please point out where is the notice? Is it a part of your pleadings? Is it on record?
Yes, Lordship, in the affidavit which the respondent number 4 has filed in the writ petition, Lordship, it has been stated that notices were given to him.
Sir, where is the notice? Is there a process of filing it on record or not?
No, it is a process.
Then where is the notice, please?
Lordship, then Lordship may give me some time so that I can place it on record, Lordship.
What do you mean sometime? Time was already given. All right, day after tomorrow.
Lordship,
Yes. Why did you file in the writ petition? Where is your response that no, we have done it after due notice? Where is your response in your affidavit? Read. And who was supposed to give the notice? The employer.
Lordship,
Where is the employer's affidavit? Mr. Chaudhary, can you refer to the affidavit
Yes,
of the additional chief engineer?
yes,
Where is it?
my lord, it starts at, 1 second. Affidavit filed by page 94, it starts, my lord.
Yes. You represent the additional chief engineer also?
Yes,
Lordship.
yes.
Yes, read the affidavit.
My lord, they are referring to notices where they said I should progress my work. There is no notice for termination. In fact,
And where does
there
the contract say? Notice before termination?
Yes, it has to be given.
Where
my
is
lord.
it? Where is it?
Contract aspect.
Termination.
Yes, termination clause I have shown, my lord.
Yes.
Page number 82.
72.
Page 82, my lord. The employer or the contractor may terminate the contract if the other party causes fundamental breach of duty, contract.
Hmm.
Then, my lord, E. Engineer gives notice that failure to correct particular so and so.
Yes, yes,
Contractor
yes.
does not maintain so and so.
Where is the notice under 59 2E? Read page 82.
Lordship, may kindly give me some time.
They have learned counsel, Mr. So and so submits that notice under section clause 59 E 2E of the contract.
And the ADM
Seek for termination of contract was given to the contractor, appellant contractor before terminating the contract in question.
Lordship,
He prays for and is granted short opportunity to bring the same on record.
Lordship,
And if the statement is wrong, you know the consequences.
Lordship.
My lord, status quo as on today be maintained, my lord.
Till next date. However, we find that before the writ court, no such pleading was made in the affidavits filed on behalf of or any of the respondents. Thus, till next date, status quo as it exists today shall be maintained regarding the works in question. Replaced on 16th May.
Item number 21.
If you have, Mr. Counsel, if there has been a blunder on your part, you better rectify it at your end
Lordship,
rather than getting some other kind of order from this court.
Lordship.
This is a high-handed action on the face of it, extremely high-handed. So the consequences might be serious for your CM. Okay.
Item number 21.
Yes.
May please, Lord. So here is the case, my lord, where the, my lord, the required qualification of grade 4 employee for promotion to the post of junior assistant requires graduate qualification. And whereas
Graduation.
and whereas the LD assistant for promotion to the post of senior assistant does not require such qualification.
So you have challenged the validity of
Yes,
the rules.
Yes, ma'am.
Let the other side respond.
Yes, ma'am.
Issue notice. You are appearing for all.
Yes,
Mr. Bodloy appears for all the respondents.
Respondent number 1 to 6, Your Lordship.
1 to 6
Private and either private respondents.
are private respondents.
Yes.
Appears for the respondents numbers 1 to 6. Sufficient copies of writ petition be provided to Mr. Bodloy. Requisites for effecting service on the response numbers 7 and 8 be furnished within 3 days. Thereafter, process be issued to such respondent.
Obligement.
Rule is made returnable in 6 weeks.
Number 22.
May I please, Your Lordship?
Yes,
My
please.
lord, the electrical junior engineers are a little in a problem in the electricity board. They are initiating the recruitment process for appointing junior engineer electrical.
Yes.
The problem is, my lord, the cutoff is for applying is fixed at 60%.
So they need well qualified people. What is wrong?
No, that is all right.
Then
Qualification, minimum qualification could be
it's all right. They need a particular benchmark.
true, but I'll show from the record also.
Yes.
Milord, the idea is, Milord, the Constitution Article 16 gives not only a right not to get the employment, but the right to be considered. That's the fundamental right. And Article 41, which is in the directory, which is a directory policy, Milord, that also ensures that state should make attempt to give right to work.
Sir, qualification,
context-
minimum aggregate marks are fixed in every recruitment process. What is wrong in it?
True.
Yes.
But I have yet to see in a post like this, earmarking 60% as the basic Milord, the entry.
Entry level. So what is wrong? They are asking for engineers.
True.
So
it is not
and
confined.
they have ample number of aspirants available.
Milord, that will depend on how many applications are.
Let the applications come. We'll assess if there are sufficient number of applicants. Why do we need to interfere in this
No,
benchmark?
There are two things.
Yes.
One is, Milord, I'll show your lordship can have a look at the state government's own Milord advertisement. So far, two advertisements I have annexed, Milord, at page 48 and page 55.
Yes.
55 is for engineer itself. Junior engineer civil.
Civil. So all right.
No,
The
there is
nature of duties, can they be equated, sir?
No, that is all right.
Yes. So you give us one judgment of Supreme Court which says that you can't keep a particular benchmark.
No,
As a-
I'm not on that.
Then
Your benchmark you may have a benchmark,
then
but if you limit it to only first class, the entire chunk of the, suppose a person is getting 59. Why should
Yes.
he not get a chance?
you will not get, that is the
There
benchmark.
is no rational.
We have cut off in the judicial officers recruitment.
Yeah.
What is wrong in it? Tomorrow you will say that don't keep the cutoff. Let
No,
everyone apply. Then
Please understand me what I.
you know we are trying to do the just to the best of our ability.
No.
Yes.
I am trying my best.
Yes.
Because the point is not whether you can have a cutoff. You can certainly have a cutoff.
From your statement, one anecdote comes to mind that a lawyer can even argue before a lamppost. So assume that we are lampposts.
I'm sorry, but I don't
Okay.
consider you.
Carry on.
that,
You just said,
or any-
try to understand.
No.
We are trying to do that, sir.
No, that is because
Yes.
that's a way of saying that kindly try
Okay,
to
okay,
understand what
please.
I'm saying.
Please carry on. Yes.
That is not, because I am not suggesting that your lordship is a lamppost.
Okay, please carry on.
That is far from my. What I am saying is, we have to see the light in the light of Article 16.
Right.
It is a settled law that although you don't have the fundamental right to a work, but in matters of public employment, you have a right to be considered. So Supreme Court has also said you can have a qualifying benchmark for entering into the competition. That is understandable. But it can't be that so unreasonable that a person acquiring the diploma is not in a position to enter, even if he gets 59%.
Yes.
That will be absolutely negating the right conferred under the Constitution. It must be reasonable. We must see the nature of the job, see the status of the job. It is a junior level thing. You have got a diploma as per the requirement from a recognized institution for a 3-year course.
Yes.
Therefore, you can't just stop them from getting jobs. Then it will be absolutely, it is one of the highest educated unemployed youth state. If these people can be stopped even in the entry point, the right to be considered, which is conferred under Article 16, gets violated.
What are the relevant rules of recruitment?
Kindly see, the relevant rule is below. APSC advertisement is at page 19.
Sir, rules, service rules of the engineers.
And the clause is
Electrical engineers service rules, sir.
yes, below that your lordship will get at page 31.
Yes.
31.
Please.
The
31.
relevant rule.
Read, sir.
8A. Qualifications for direct recruitment.
Right. So there is a rule
Yes.
which prescribes this is virtually a measure of shortlisting. So that the number of aspirants appearing in the written test can be limited. Leaving it open to all candidates would make the selection process for written examinations unwieldy and unmanageable. So they have devised a measure that when we are dealing with recruitments, we want to have a shortlisting exercise. This is a measure of shortlisting.
I quite see that point. Below.
Yes.
Qualifying, I am not saying that you can't have. Qualifying has to be a reasonable way of looking at things, considering the nature of the job, nature of the employment, nature of the person we are dealing with.
Yes.
That if we look at, there is no rational reason why a person doing the required diploma 3-year course from a recognized institute cannot aspire or cannot enter the competition to have a job in the electricity board under the category of a junior engineer.
All right. Yes.
That with respect is difficult. At page 31, rule 8, the proviso is therefore under challenge.
Yes.
The requirement is wholesale 3 years or 4 years diploma in the respective branches of engineering, electrical, mechanical, instrumentation, electric, information, technological, and all that from government recognized institution. Then provided that the candidate secures a minimum aggregate marks of 60%, or its equivalent, or being eligible for admission into written test, 50%, or its equivalent in the case of scheduled caste and scheduled tribes.
Yes.
So this is something which really negates the right to be considered.
Mr. Counsel, is shortlisting exercise, can it be done even before permitting the candidates to apply? Shortlisting can be done in written examination, that there can be 2 steps.
Yes.
First step, a cutoff, a benchmark is taken. The ones who do not secure the benchmark, they are ousted. This is too harsh to our mind. He's right in saying so.
The basic reasonable nexus of the object should to be achieved is that we need to qualify them.
Yes, so you why then go by merit, simply marks obtained in the qualifying examination.
Same arguments were made before Honorable Supreme Court, my lord. In twice, my lord, the Supreme Court decided in negative, my lord.
Let's see.
2008, 6-8 SCC.
Let's see.
One of the person will have, for example, 59.9.
Sir, if it is 60 and if it is justified, we can't go relaxing the educational norms
That is right.
by exercising the writ jurisdiction. Let's see what Supreme Court has
That's
to
why we
say.
have come for challenging the order.
Let's see, sir. Let's see. Yes, please.
Paragraph 23 to 27, my lord.
The qualifications for recruitment were posted laid down in terms of the statutory rules. The fourth respondent raised the contention before the tribunal that several persons named in group G of the requisition had occupied the very post of archaeological department, although they were experts in so and so. The aforesaid
That is regarding the nature of course pursued. They are on percentage even before you allow them to enter for the written test.
Yes,
It was a different issue if you have given an indication in the rules that we will select the persons on the basis of marks obtained in their qualifying degree. Right? That would have been a different. There you could have put that, all right, we'll consider only as per the merit of marks obtained in the
my lord.
the degree. But here you are saying that this is a measure of shortlisting even before allowing the persons
Yes.
to participate in the written test.
Yes, madam.
Show us some judgment to that effect.
Paragraph 25, madam.
Yes, read.
The statutory authority is entitled to frame the statutory rules, laying down the terms and conditions.
This is not qualification, Mr.
Yes, it is
Counsel.
there, my lord. It is
Yes.
there. Terms and conditions of
As
as also the
60% is not a qualification. This is a cutoff you have prescribed. Come out with a judgment of cutoff even before the written test. Can you do that?
My lord, we say, my lord, that a person to be qualified has to obtain.
Gentlemen,
66
many a times it happens that a person may not be able to perform
True, my lord. But in the
in examination, but
paper-
in the written test, he may exceed, he may excel.
True, my lord.
There are instances in judicial services where a candidate has secured much more, many higher marks in the written examination, but in the viva voce, the candidate fails.
True,
So there are different circumstances. Give us one judgment which says that where you are holding a qualifying written examination, you can have a cutoff even before allowing entry into that written
I
examination.
understand. I understand.
Show us some judgment. This doesn't apply. This is qualifying degree, a different thing entirely.
The junior
Tomorrow,
engineer I was referring, that is at page 51.
51. What is that?
At page 48, we have annexed that.
Yes.
uh,
State says
the
that for junior engineer civil,
under Director of Inland Water and so and so. And the qualification is mentioned below, serial number 5. 3 years diploma in engineering, mechanical, civil, electrical from a government recognized institute approved by AICTA. That's all that requires.
that's right. That's right.
Post it tomorrow, my lord.
If you need to make some kind of research,
Yes.
probably the Bar Council had introduced this minimum percentage for enrollment
Yes.
Yes.
that was struck down by Supreme Court.
Right, you're absolutely right. There is another case relating to ladies being employed.
Bring those judgments, sir. Let them complete your instructions.
2008 3 SCP, page.
But there has to be, you have to find out a specific judgment on this proposition.
Yes.
Let them respond.
Yes, I think, you know, it's a matter which needs a little investigation, because your lordship will see that even under their own rules, they provide for a written test and then interview.
That's what they are saying, so that whether there can be a shortlisting even before permitting the candidates appear in the written test.
After the examination, it would have been different. I will post it
That
tomorrow.
shortlisting is permitted. This is a measure of shortlisting
I know.
even before giving a chance to the
I know.
candidate.
Yeah.
I'll come up, my lord, tomorrow or day after. my lord.
That shortlisting takes place by APSC.
In a competitive examination, you can do that.
I understand. my lord.
But in a theoretical examination, doing it shortlisting even before giving the opportunity
That is
seems to be little,
little on the high side.
yes,
Tomorrow,
do you
day-
want?
tomorrow or day after. my lord.
day after tomorrow.
Yes.
When is the last date?
10th is the last date, you know.
10th.
10th.
So you have come at the last moment. The advertisement was of March. By an interim measure, we can't relax this benchmark. That goes across the board then, allowing everyone who is having any number of marks. Where do we fix the benchmark then? So you are a little late in the day, sir.
He actually mentioned it, there was vacation, therefore it took a little time. Huh?
April 10th of our online application.
Online will start from April 10th. So tomorrow, there.
Online,
It's online applications were started from April 10th.
so now it's almost a month, sir.
True. I
May
quite see
indicate
your
one
lordship
thing, my lord.
point.
Closing date for online application is 24/2023, madam.
20th April.
Yes, madam.
No.
So your date of
Sorry,
file,
sorry, madam, sorry. It's a different address.
We have said it is 11.
where it must be indicated in the notification itself.
Yes, madam.
Last year we have mentioned somewhere.
Yes, lordship, page 20.
What is the date?
Is there
Page 20.
Page 7, we have said 11/5/23.
Last date for payment of online fee 11/5, madam.
11.5. All right. So you come out with your response. But then this has to be decided by interim measure. We can't permit.
Yes,
There
yes.
can't be a provisional permission because then that will be opening the floodgates.
No, your
Any
lordship can
date-
issue a notice, let them file their.
You are appearing
application.
for all?
My lord.
Let them file their applications, that.
My lord, just a-
No, no. If we allow the petitioners to file the applications, we have to allow everyone who is having any number of marks. How can we do that? That will be giving final relief.
No, this is only, it will be confined to these persons.
How can it be, sir? We are virtually by an interim measure, you are trying to, you are asking the court to lower a benchmark, fixing the rules.
I'm not saying that.
That's what it is
For-
then.
For the purpose of, balancing the equities, if your lordships feel there is an.
You are late, sir. You are late in the day.
No,
The advertisement was issued on 30th March.
no, that is, I quite see.
So
that.
then this interim order can't be given.
No, what I am suggesting for your lordship's kind consideration, considering the equities. suppose,
First, let them come.
application
Today it's
is
8.
entertained.
Let's hear them on 10th. There's one more day left. 10th.
As your lordship.
Except two, my lord, I'm appearing for all, my lord.
Who is two?
Two is Deputy Secretary, Public, APSC, my lord, Public Service Committee.
APSC is just the
They have their own.
service provider.
Yes, ma'am.
Yes.
They are governed by your rules.
My lord.
All right, appearance mark कर दीजिए.
Item number 23.
My lord, may kindly peruse order dated 21/12/2022, my lord. This pertains to, my lord, proposed eviction in Gwalpara. There was a suo motu PL file registered by this honorable court.
So we'll fix up in the environmental bench.
My lord.
All right. List. This writ petition involves issues pertaining to eviction from
In Gwalpara district, my lord.
Forest Division in Golpada district.
Hello.
So what has happened in the PIL,
My lord, PIL was a suo motu PIL. We were directed to cause.
which
my
is
lord,
pending? It
It's
is pending.
disposed of, my lord, with a direction to evict, my lord,
Okay. Now what is the prayer in this petition?
not to evict, my lord.
Not to evict. What do you say, sir?
My lord. My lord, these petitioners have a peculiar, my lord, case, my lord. They are belongs to traditional forest dweller community, my lord. My lord, the Garo community, Coast community, and they
you are
allowed to
asking
stay
us-
on the land.
You are asking us to review the order passed in that division bench.
In fact, my lord, in that
Well-
PIL, one review was filed later on that was dismissed
Why?
because this court,
Who was the applicant in the review?
different applicant.
My lord,
How do you surmount this order?
my lord, in fact, my lord, the petitioner's case, about the petitioner's case, nothing has been discussed in the order, my lord. They are traditional forest dweller and they are allowed to stay in the land.
They
Since
are
1965, my lord. There is an order of the government, my lord.
order of the government
Yes, my lord.
for
Allow to stay, this category people to stay in the land, my lord. Annexure 2, page 24, my lord. There, my lord, all are belonging to Garo community and Coast community, and they have migrated from Pakistan, East Pakistan, and they are allowed to stay as an refugee, my lord. And they are allowed to stay, but without giving any permanent settlement. That is the condition of this order, my lord, at page 24.
24.
I am directed to say that after careful consideration, government in revenue department have agreed to make available lands as per list and close to the relief rehabilitation department for rehabilitation of East Pakistani refugees. Particular care should be.
That we can understand, sir, but whether they have been allotted or
No,
permitted
my
to
lord.
stay on that forest land,
They are
that's a
allowed to
question of
stay-
fact now.
They are allowed to stay, my lord, without.
On which part of land? We don't know.
My lord.
This
That
order
is-
doesn't say that you are on this stay, permitted to stay on the Golpada forest.
My lord, 3 revenue circle, my lord.
Hmm?
3 revenue circle, they are allowed to stay, my lord. One is Matia, one is, my lord,
Where is
Matia
Golpada in
circle,
this? Where
then
is
one
the
Rockipur
Golpada?
circle.
Does it indicate anywhere Golpada
Yes, my lord.
forest?
Yes, my lord.
Read.
In Lordship, may kindly have a look at, my lord, page 26, my lord.
Yes, please.
Page 26, my lord. the circles are mentioned.
Hmm.
It is Goalpara, district and subdivision Goalpara also.
Hmm. What do you say to this one?
My lord, may kindly see the notice, my lord, at page 22.
Yes.
We are not against wherever, where they are, my lord, possessing land, my lord.
If they-
We simply say that you should go from the forest land. Now they are
Ish.
before your lordship saying that they will be affected. That itself means they are inside forest land, my lord.
That's all right. But if you have given them the permission to stay,
True, my lord. Page,
then if you have to evict them, then rehabilitate them. That's the only way out.
Page 25, my lord, will perish, my lord.
Yes.
I am also to say that in making allotment of lands in question, the allottees will not be given ordinary annual or periodic patta, but some kind of an allotment paper, the terms of which are under consideration of the government. my lord.
Yes.
So now, my lord, the law has changed. The Forest Conservation Act says
You can't. So then rehabilitate them.
there
They
is,
are not unauthorized, basically.
there is a,
You have authorized them to stay on the land.
there is a policy of the state, my lord, for rehabilitation. For
Yes.
that they have to apply and they have to prove that they are landless person, my lord.
The question is, they are all refugees. So we can presume that they are landless. You gave them an area of land to stay. Now you are saying that it is a forest land.
It's a
Then why did you allow them to stay on that land earlier?
Honorable, kindly appreciate.
When was the land declared to be a reserve forest? That would be the
instruct-
question.
That instruction we have to take because, my lord, the letter they are showing, my lord, that-
If the reservation of the area as a forest is subsequent, then they have a substantive right.
my lord, may I submit one thing? my lord?
Yes.
Under the Forest Rights Act, my lord, for other traditional forest dwellers, they have to put in 75 years of, my lord, position. prior to
Gentlemen,
2005.
that is suo moto on their behest. When they come out that we are dwellers since 75 years, here they have an authorization of the government.
For, my lord, for possession of some land.
Yes.
We don't know, my lord, from this letter, it doesn't indicate the beneficiary, my lord. Page 24 doesn't
So
indicate.
you
the
file a counter affidavit
My
to
lord,
this.
yes.
All right. But government counsel, Mr. So and so appears on behalf of all respondents.
My lord, I'm appearing for
You show the appearances who are appearing.
my lord, my lord, yes. 2, 3, 4, 5. 2, 3, 4, and 5, my lord.
2, 3, and 4, and 5. Who appears for respondent number 1 and 6?
One, my lord, every department has
Rehabilitation.
their own standing council, my lord.
Respondent number 1 and 6, circle officer.
My lord.
Appearance, sufficient copies of the writ petition be provided to the council representing the respondents who pray for and are granted 2 weeks time to complete their instructions.
But may I please for my lord to status to as regard their possession.
You instruct the
My lord,
authorities.
there are so many encroachments, my lord. There are orders passed by your lordship. One order.
That will be a
interim order, my
contradictory
lord.
order. That will be a contradictory order.
Obliged, my lord.
Number 24.
That will be going back on our own directions.
My lord.
How can that be done?
Obliged.
Deep lovely.
List on 23rd May.
Deep level.
Deep lovely.
This is. Yes.
Regarding the temporary shelter, my lord.
Yes. Where is Mr. Kumar? He's not here today.
My lord, he is before the apex court today. Another PIL has been listed today, my lord.
Okay. Yes. What is the state stand?
State stand is lordship, so far as that there is a direction to provide them water. We have already started.
Hmm.
There are illegal encroachers there. In fact, lordship, there was a PIL, 2 PILs. One is 88 of
That order is already there before
Yes,
us in
yes,
23.
lordship.
But item note.
And most of them are already rehabilitated.
Hmm.
They have to be rehabilitated under the government policy.
Obviously,
Uh,
obviously.
those who are entitled, they were all.
Like, yeah, you see, the issue is not so small. The issue is that if you allow these people to live in this situation, the spread of illnesses
Absolutely correct.
from these kind of shelters, that will cause a problem to the other populace.
Yes, lordship.
That is the basic cause of concern here.
Yes, lordship.
First thing, children you can't treat in this manner. We are not bothered about who the people are, but you treat the children with dignity. That is the mandate of law, Juvenile Justice Act.
No difficulty.
They will be, once you are evicting the family, the children become children in need of care and protection. That is what the concern of the court is. That is what the news report was about. Children being hospitalized. So we ensure proper hygiene facilities, proper water, and if the families have not been rehabilitated, then provide something for the children. That is what the broad idea is. And how many more shelters are there?
About 800.
800 shelters. No, 800
in this
residents.
in this particular area.
Shelters means individual families.
there are 350 families and total list I have received is about,
That is number of persons you are saying.
no, lots.
No, no, we have asked you the number of similar shelters, people who have been
That
ousted.
information is yet to come across the state.
So in the meantime-
Across the state, Lordship, we have our own shelter homes as well as the camps. But this is not a camp nor a shelter.
Camp situation, Sakya, you understand that now the state is in forefront of developmental issues, development plans. You don't leave shanties anywhere.
Lordship.
If they are not entitled to stay in the country, you take steps accordingly. That is not your case. They are encroachers on forest land. We do not ratify their action by any means. But if you want to throw them out, then you have to provide them rehabilitation.
Lordship,
This happens, we will tell you one thing.
Lordship.
This doesn't happen without the connivance of your officials. You traveled from the city to the airport to see the situation where the highway is widened. On both sides, you have encroachments coming out. You notice that? Does it happen without the connivance of the officers? There in Rajasthan, we passed an order that if we notice any kind of these encroachments, the local officials concerned of the municipality, they will be held responsible. It doesn't happen if the officers are vigilant. This is actually sponsored. In one part of the road, you see pipes are put up. What does it indicate? Rest of the land, it's free for you to use. Why? So this is not a problem of people encroaching on their own only. This has got many more dimensions.
I fully agree.
Over a period of years together, you allow the people to stay in the forest. What were the forest officials doing?
Exactly. Lordship is, I cannot agree more to this.
So
The
then-
hills, in Guwahati, the hills.
Yes.
Same is happening.
And this is not the only forest area. You will find number of forest areas.
Lordship.
Same situation. There in Rajasthan, there is a town called Kumbhalgarh. It's a pristine forest, the hill station. The entire hill station has been taken over by concrete structures. With my own eyes, I have seen areas from where you could see miles in the open mountains. Now nothing is visible. Only buildings, buildings, buildings. So it doesn't happen without connivance. So that is the broad idea.
Let me come out with a phrase 10
And
this time.
till then,
So what can be done
for
with this?
policy for the children, how you will tackle the
Yes.
issues.
No, we cannot segregate the children with the families because they are very young. So we have
No,
to,
there is no question of segregating. Provide them appropriate amenities. That's what we want.
Lordship will not pass any order.
No, no, we will
Let
not
me come
pass.
with a positive thing on the
Okay.
next day.
The Psychia submits that considering the issues of children which have been taken up by this court in the suo motu PIL, the state government would be coming out with an appropriate solution within
Lord.
next 2 weeks.
Lordship.
List after list on 25th May.
Let it come out first, 25th
June.
May. Yes, Lordship. Perfect. 25th.
3rd June, 2nd June,
2nd June, Lordship.
2nd June.
Deeply obliged, Lordship.
Number 26.
And you need to take care of that airport road. You'll soon find that road reduced to a bylane, I tell you, we tell you. Just this time when you are proceeding to the airport, notice that part.
Lordship.
Yes.
May I please, Lordship. My lord, we have challenged the order that is page 73, my lord.
Yes.
Yeah, my lord, if I apprise your lordship about the facts of the case in nutshell,
yes,
I think it would be better for understanding. My lord, there was one school named Gunaipani ME Madrasa.
Yes.
Gunaipani Madrasa in the district of Dhubri. So that Madrasa was situated at village Gunaipani. But in Gunaipani, there are so many other educational institutions. So there is a public proposal that it should be shifted to village Bauliri. Thereafter, the managing committee of the school took resolution that the Gunaipani Madrasa should be shifted to village Bauliri. And that was approved by the authority, my lord.
Yes.
That was approved. Thereafter, my lord, one teacher who was ousted from the school for his some misdeeds, he opened another school by the same name. And he got some favor of the departmental officers.
Yes.
Then matter was inquired in details by the joint secretary. Now, Lordship, kindly see page 44. Page 44. Here, the joint secretary, government of Assam, secondary education department visited.
So read the para 20 of the impugned order. That was what our first impression was after you opened the arguments. This has to go to the civil court. Can't be a matter of this writ petition.
No, that is, my lord, here I am reading, of course.
Read para 20 of the impugned order.
This court is of view that there has to be finality to disputes, especially when the disputes relate to factual issues. As the impugned inquiry report has come to a finding that the Gunaipani Madrasa run by the respondent number 7 is the original madrasa, this court does not find any ground to interfere with the said finding. If the petitioner is aggrieved with the same, he can always approach the civil court as a writ court is ill-equipped to take evidence. The above being said, the inquiry report, which is annexure A to the affidavit in opposition filed by respondent number 7 to 9, has not been put to challenge in this writ petition. The petitioners have only prayed for setting aside the provincialization order dated 4/2/2021, and for provincialization the petitioners, there is no prayer for setting aside the inquiry report submitted by the Deputy Secretary, Elementary Education Department, which has been made in pursuance to the order dated 22/11/2019 in W. so and so. Now, my lord.
Where is that order? Where is that order? Can we have a look at this order, please? 22/11/2019. Is that order on record?
2/11/2019.
Yes.
My lord, first thing, my lord, this entire case is based on a order of the government. My lord. That order of the government may be seen page 64. My lord.
Yes. So we are precluded from having a look at that order of this court.
That was set aside by the Honorable High Court, but that was not taken into consideration. Kindly see page 64. This is the order of the government. Operative portion may be seen page 65, bottom. Decision. Considering the above facts and materials in hand, the school Gunaipani Madrasa, in which Muhammad Chanmia is functioning as headmaster, situated at Gunaipani village, is found to be genuine and eligible for financial assistance and other benefits provided to non-government educational institutions. Accordingly, the Director of Elementary Education Assam is directed to issue necessary instruction to all concerned in this regard immediately. This is issued in compliance with the order dated 27/7/2015 passed by Honorable High Court in IN number so and so, arising out of WC number so and so, and order dated so and so in WC number so and so. Now, this order was set aside by the Honorable High Court, my lord. That I am inviting your lordship. Kindly see page
64, 65F. Yes.
65A, operative portion may be seen, page 65G.
Yes.
65F may be seen from.
Order dated 6/12/17 is set aside.
65.
They are directed to
Para 14.
convene a fresh inquiry.
So
Yes.
that was set aside.
Yes.
But though that was set aside by the High Court, at first, my lord, we got some interim protection because we are the teachers since the year 1994. And we have submitted 33 documents right from the beginning, that is 1994 till today. But the respondent number 7 to 9 could not submit any initial documents, only subsequent false documents.
So read
now, lordship,
para 15, the direction given by this court.
now, lordship, I invite your lordship, kindly have a look to every officer is saying that take action upon the private respondents. That I will show. Kindly see now, my lord, page 127, first. 127. Operative portion, 127, A, bottom. In my opinion, financial assistance and other benefit of government, Lordship has said.
Yes.
In my opinion, financial assistance and other benefit of government and other agency may kindly be provided in respect of Gunaibani Madrasa presently located at Bauli.
Where is the last report which is referred to by the learned single bench, which they filed along with the affidavit in opposition?
My lord, that superior officer made an inquiry after visiting the guardian's house and
Sir,
students.
can you show us the last report which is referred to?
Yes, last report I can show.
Please.
But before that, I wanted that every officer, every time when they visited, they found that that school is fake, and everybody recommended the action should be taken against respondent number 7, 8, and 9 for preparing false documents. Now, inquiry report that Lordship may kindly see, the inquiry report, it is also dated nil, madam. The inquiry report has been prepared, but that is nil. That is not given there. That may be seen page 60.
Is it not page 68?
My lord,
Seems to be at page 68, sir,
60.
which as per the learned single bench was not
Yes, page
not
60.
challenged. That
My-
report was not challenged by you.
Because document that was not furnished to us.
It was filed along with their affidavit in opposition, sir.
My lord, one thing is clear. That is why, my lord, we filed an IA. That the copy is not furnished to us, and that IA is duly recorded in the implement order. So we filed an IA that the order which was set aside by the Honorable High Court, on the basis of that order, the provincialization has been made in respect of the services of 7, 8, and 9.
Either
Now,
we are not clear or you are not able to understand. We are saying that there is an inquiry report
Yes.
pursuant to direction given by this court in your writ petition.
that is true.
That inquiry report you did not challenge.
That inquiry report was not provided to me.
Read
but
your-
it was
read your-
filed by the respondent.
Read your,
That was brought to the notice of the Honorable Court by your filing an IA. By
read,
your
your
filing an IA.
read your averment in the appeal that this copy of the inquiry report was never provided to us. Read from your writ appeal.
Right, appeal, yeah.
Yes.
Page may be seen, page 20, madam. Grounds on which the conclusion decision of the learned single judge is challenged. Further, learned single judge has committed error in passing the impugned judgment which has been passed on the basis of latest inquiry report, but the said report has totally failed to examine the 33 documents submitted before the inquiry officer on 2/9/21 by the appellant number 2, which were the documents since the day
Sir,
of-
where is the averment that this report was not provided to you? They are challenging that report in appeal,
Yes,
where there was no challenge in the writ petition.
it was challenged in the IA that we were not provided this
Then
inquiry
that
report.
would have been a ground in this appeal also, sir.
Yes, appeal is, that is.
They
what-
have filed it along with their affidavit in opposition. You should have filed a challenge there immediately that this report is not acceptable to us. That report is based on an order passed in your writ petition.
My lord, that may be seen also page 22.
Yes.
Page 22:7. For that, when the matter was under process of inquiry in the highest level of government, suddenly on 4/2/21, a list was published where it can be seen that the posts of respondent of 7, 8, and 9 have been provincialized. So though the earlier high-level inquiry report categorically held that the Gunaipani Madrasa headed by the appellant number 2 is genuine school and the school of National 7 is not genuine. Overall inquiry process was under development pursuing the Honorable High Court's order, and at that time, the official respondents hurriedly provincialized the post of certain teachers of the false Madrasa, namely respondent 789, which has caused serious injustice to the appellants, genuine school and its eligible teachers like appellant number 2, 3, and 4.
Mr. Mahmood.
Virtually made inquiry reports meaningless. So, my lord, I understand.
Sir, your argument, categorical argument before this court now was that inquiry report was not provided to your clients.
Yeah, yes.
Right? We are trying to third time put you a question that where is this pleading in your appeal?
Then, my lord, I may be allowed to file additional affidavit with.
What's for, sir? That report was not challenged in the single bench. There is no averment here.
Challenge was, my lord, IA was filed. That IA, on that day, IA did come, my lord. Kindly appreciate this. On that particular day, when the input order was passed, IA came. But instead of disposing of the IA.
When was their affidavit in opposition filed? Let us see. Where is their affidavit in opposition, please? Page number.
Affidavit in opposition, my lord. Their affidavit in opposition.
Yes, please.
I think it was.
Have you filed it or not? Seems not so.
It is not.
If then your appeal will go on this ground only.
Actually, my lord, the thing was that, my lord, our center was on IA. That.
If you have not filed their affidavit in opposition on record, we will dismiss your appeal on this ground alone.
No, my lord, that cannot be this. I may be allowed to bring all these things on record. Because we have a good case, every officer is justifying that our skill is genuine. Lastly, without giving
The
a
counsel
date,
for the appellant is directed to place on record the entire set of pleadings in the writ petition, including the affidavit in opposition filed by the respondents and the documents annexed thereto.
and also the IMN.
Whatever you want to file. If praise for it is granted, 4 weeks time to do the needful.
Not in the writ petition, a writ appeal manner.
Sir, those
Lordship have said that
in writ petition, yes.
No, that we filed, but your lordship has ordered that entire documents should be produced in writ petition.
Documents filed in the writ petition on record of this appeal.
Yes. That is obliged.
ले लीजिए पूरा कर लीजिए ना लिस्ट एक दो मैटर है आप बिफोर हियरिंग ले लीजिएगा यस
Number 28.
None present.
I'll tell about the timing.
You're here.
20.
Yes.
For the timing, Lordship is in lighting.
Pass over.
Number 29.
We are seeking some more time to file it. Our affidavit.
Counsel, Mr. So, praise for it is granted. Further opportunity of how much?
3 weeks, my lord.
3 weeks to file.
Status quo order, Lordship.
3 weeks time to file the affidavit in state order dated, interim order dated so shall remain in currency.
Obliged.
Number 30.
In this case, my lord, by your lordship's order dated 27th of February 23, my lord.
Yes.
Please to place my lord, the scrutiny committee report, my lord. In seal
Yes.
cover.
Okay.
I've got the report.
Let's see. Issue relates to provincialization of the.
Yes, my lord. The issue is whether I joined this school in 2006 or in 2011
Okay.
at the venture stage.
From the above facts and circumstances, it reveals that the petitioner Mumtaz Begum was appointed on 2/8/2006.
Yes.
That is what your case is?
Yes.
Yes, what do you say? We'll provide a copy of the report to both the councils.
Let us go through the report, my lord, and then thereafter we'll find.
The inquiry report, a report of inquiry conducted in pursuance of the direction given by this court on 27/2/2023 has been produced by Land Council Mr. Katniar in a sealed envelope which was opened. The report has been produced. The conclusion in the report is that the petitioner Mumtaz Begum was appointed on 2/8/2006 in the Akabasti ME school as the 6th teacher and was upgraded to the post of 5th assistant teacher of the said school on 8/7/2011. Certain other conclusions are drawn in this report. A copy of the report shall be provided to Land Council for the appellant as well as the Land Council, Mr. Ganguly representing the respondent number 1, and so also the State Council. The report is taken on record. Pehle likh lena. The interim protection provided to the appellant shall remain in currency list after 4 weeks.
Deeply. Number 31.
Yes.
Your lordship,
Hmm.
we have.
You were to file certain application.
Yes.
Yes.
Lordship, we have filed that.
You filed that. What is the substratum of your application? Hmm. What have you stated, madam, in your application?
It is on page number 46.
Yes.
Number 4.
Sale certificate. All right. So the petition is that you are not handing over the possession.
My lord, and for
What has happened thereafter?
then, my lord, at page 49, my lord, they approached the DC and the DC directed the circle officer to maintain the law and order situation.
Mhm.
And accordingly, the bank approached at page 50, my lord, bank approached the SP
Hmm.
for depositing of the fees towards that providing the security. But,
Yes.
my lord, they didn't receive it.
They have refused to receive.
My lord, and for that purpose, my lord, in the absence of the police force, my lord, they cannot give me the opportunity.
Right. Who appears for the Home Department, the police? Is the department a party?
No, my
Department of
lord,
Home?
initially that was not, my lord, but by virtue, your lordship is directed to hand over a copy.
Yes.
And accordingly, the bank has.
Who is the, madam, you are representing the Home Department? Your name is not there probably. It is there?
No, my lord.
No, all right. The appearance of MS Bora, the council representing the Home Department, shall be indicated in the call list. Copy of the application dated affidavit in opposition filed by the respondents shall be provided to MS Bora, who prays for the copy of the writ appeal, writ petition, as well as the affidavit in opposition shall be provided to MS Bora, who prays for and is granted 7 days time to complete her instructions. Why the police is shying away? You let us know. There's a written application by the bank. Your SP has refused to accept the amount. Give the instructions. All right. List on 26th May.
Much obliged.
Much obliged.
Number 33.
Please, your lordship. I don't know what that is. But this is a matter, this is a appeal.
Before my learned friend starts, I have some preliminary objection about the maintenance of the petition, writ appeal itself.
Okay.
First, it that the appeal has been filed by the judicial professional. Now, as you see, the
RP. RP has filed the appeal.
Now, he is not agree person. Now, without there being agree person, he cannot file an appeal. Secondly, after the judgment of learned single judge,
the RPH filed an application for liquidation before the NCLT. Now accepting the judgment of the single judge, the liquidation has been filed. The liquidation can be filed without application can file only when the resolution process is failed without it is not.
Right.
Once he has accepted it and files an application, how on the other hand, same said, he challenges the order of the single judge and files the application. Thirdly, you also may see the liquidation provision, section 30.
IBC?
Please.
Yes.
You know. Section 33, Miller.
Yes.
Who will also see, Miller?
IBC insolvency bankruptcy code.
Not IPC, IBC. Insolvency bankruptcy code.
Yes. Section?
Section 33, Miller.
You are appearing for
Miller, I'm preparing for the respondent. Miller.
respondent. Who is the respondent?
Petitioner.
Krishna.
The financial criteria laws with the voting.
Creditor, all right.
Financial criteria with the voting percent of 2.5%. Only 2.5.
Yes, yes.
Yes, you are ready reading?
Miller, Section 33, Miller.
Mhm.
Initiation of liquidation.
Mm.
Where the adjudicating authority, before the expiry of the insolvency resolution process period or maximum period permitted for completion of the corporate resolution process under section 12 or fast track corporate resolution process under section 556, as the case may be, does not receive a resolution plan under subsection 6 of section 30 or rejects the resolution plan under section 31 for so and so, he may pass an order requiring the corporate debtor to be liquidated in the matter laid down in there. So, my lord, if the resolution process is not filed within the time period, it is expired, the adjudicating authority can do it.
Right.
See two, my lord. Where the resolution professional at any time during the corporate resolution process, but before confirmation of the resolution plan, intimates to the adjudicating authority of the decision of the committee of creditors.
You see, approved not less than
Not less
66.
than by 66% of the voting shares.
Yes.
To liquidate the corporate debtor, the adjudicating authority shall pass a liquidation order so and so. I am placing this section below for the purpose. In this case, the adjudication professional could have filed application before NCLT before the expiry of the resolution process. He has filed it after the expiry of the resolution process. It can be only at the instance of the creditors by voting process. There is no
voting.
resolution. There is no resolution of the committee of creditors. There is no voting, and he himself has filed it. Now I am showing it for the purpose, that the resolution professional is not independent, biased, because he is filing the writ appeal, he is filing the insolvency process.
He is supposed to act as an independent arbitrator, basically.
He himself is also giving a consent to act as an arbitrator, as a liquidator. Before liquidator can be appointed, he can give a consent. But once the order is passed by adjudicating authority, along with the application, he has also given a consent to
Act as a liquidator.
Because in my humble submission, and he himself in the affidavit, he has said in the writ appeal, that he is authorized. Who has authorized, there is no meeting, there is nothing. Who has authorized him to file the writ appeal?
Let's see his affidavit. Yes. Where is your authorization, gentlemen? Where is the authorization to file this appeal? Yes. Firstly, tell us, how are you the aggrieved person? Mr. Counsel, how is the resolution professional and aggrieved person?
Please, I'll revert. Because first of all, we had earlier filed a writ appeal against the order of the single bench, against the order of granting stay, in which PNB was also a party. PNB and RP had already filed an appeal.
the Honorable Division Bench had guarded his liberty and to take all the contentions before the learned single judge.
Yes.
We had taken that. PNB is also here a lot today. It is on instructions of PNB only we are appearing because PNB is only bearing.
Is it so? Read the instruction, please.
Please.
Where is the instruction? Let's see.
Because there is no specific, because I am the RP.
Why the PNB itself is a party? They can approach the court.
Please, your lords, but as a RP.
What is your status, sir? How are you an aggrieved person?
Your lords, I'm the RP as of
Yes.
date. As on date, I'm still the RP of the company.
Understood,
Of the
sir.
corporate lords. Yes,
Understood. Not of the company.
of the corporate debtor lords.
Yes.
Still the RP till the point the liquidation order is passed.
How
What a
the
liquidator
how
is
the
doing.
resolution professional can indulge in litigation? Tell us, please.
Please, your lords, this order is affecting IBC as a whole. This order of rejecting the extension order is affecting IBC as a whole, because of which.
Yes. So let the aggrieved persons go.
Please,
Let the aggrieved persons apply. Why? What does the RP have to do with it?
your lords, if that is the case, then no RP will go against an order of a.
They're not supposed to.
Please, your lords,
That
this
by itself
requires-
puts a question mark on the independence of the RP.
Your lords, RP is acting independently. This is only a pure interpretation of statute in this, your lords. There is no.
Irrespective, sir, whether he can litigate
Please,
on his own. On his own.
RP can file appeals, your lords. RP is empowered to protect the interest of the corporate debtor.
Let us see. Read the provision, please.
Please, your lords.
Yes.
Because section 25 of IBC, your lords, duties
Yes.
of RP, your lords.
25.
Please, your lord. It shall be the duty of RP to preserve and protect the assets of the corporate debtor, including the continued business operations of the corporate debtor, your lords.
Yes.
Please, your lords, section 25, your lords.
Hmm.
So, lords, it's the duty of the RP.
Read
So, yes, your
what
lord.
he can do for.
Yes, undertake the following actions to
Yes.
take immediate custody and control of assets of the corporate debtor, including the business.
Represent and act on behalf of the corporate
Represent, yes, your lords.
with third parties,
Please, your lords.
not with the court.
Please.
Represent and
Because
take action
RP
with the third parties.
Please, your lords. RP can file appeal. Earlier also, RPs have filed appeals.
Yes.
This has never been a question that why RP is approaching the court. Why is only RP approaching the court? Because ultimately the.
Where is the
object of-
authorization given to the RP to file the appeal?
RP doesn't require an authorization, your lords. It's by the act, because the act, I'm not an individual person. I'm a body created by the NCLT. NCLT appointed me to act as an RP of the corporate debtor, your lords.
Yes.
Yes, your lords. So in order to protect the interest of the corporate debtor, your lords, I have filed this appeal, your lords.
Right.
Was
Why
the
doesn't the
intent of
corporate
IBC
debtor, why doesn't the corporate debtor itself come forward to file the appeal?
Your lords, corporate debtor cannot approach because corporate debtor is under CIRP. The management is taken over by the RP. The RP controls the management of the corporate debtor, your lords. Hence, the corporate debtor cannot approach.
So banks are party in the repetition. Banks are party in the repetition.
Banks with the party. They are the corporate.
Bank was also a party.
Bank-
Earlier we had filed. Let me,
Yes.
Lord, I have just prepared a short list of dates to have a complete factual background of the matter, lords.
Presently, we are not on the factual aspect of it.
Please, lords.
There's a
Just the
preliminary
background of the
objection.
matter. Just the background of the matter.
Yes.
Please, lords.
You see, so far as legal matters are concerned,
Please, lord.
it's only 25(2)(d). Let's read 25(2)(d). What is the extent of jurisdiction you can
Please,
exercise?
lords. Your lords, the duties of IRP, which ultimately goes down to the RP also is also mentioned in section 18 of the Act, your lords.
Read. Only thing,
Please, lord.
so far as filing is concerned, that is provided in J.
Please, lord.
Read.
File application for avoidance according to chapter 3, such other actions as may be.
File
specified by-
application for avoidance. That's all the RP is permitted to file as such under the act.
Your lords, the RP is supposed to protect the interest of the corporate.
Yes,
debtor, your lords.
yes.
Your lords. So in this matter, your lords, what had happened was the company is now sent into liquidation, which is the last resort in an IBC procedure.
Yes, yes.
So in order to protect the interest of the corporate debtor, this is
The
just filed.
extent of IBC
Please, your lordship.
to ensure this is not an isolated provisions of clause 1.
Please,
It
your
is governed by the procedure provided under rule 2, clause 2. So for protecting the interest, what the RP can do, everything is defined in clause 2. Read that. Mr. Saraf, why will not come in clause B, 2B? Read please.
To be
Yes.
represent and act on behalf of the corporate debtor with
Yes.
third parties, exercise rights for the benefit of the corporate debtor.
In judicial, quasi-judicial or arbitration.
Benefit of the corporate debtor.
Yes.
My lord, here he is not, my lord, acting on behalf of the benefit of corporate debtor,
Then
corporate creditors,
how do you say?
debtor, you're asking me for this.
No, he is representing the corporate debtor.
I'm gonna say, represent and act on behalf of the corporate debtor.
Yes.
Now with third parties, exercise rights for the benefit of corporate and
In judicial, quasi-judicial or arbitration
My
proceeding.
lord, there is a provision that he can do it, my lord, everything on the behalf of the corporate debtor.
So that's what he is doing.
With the authority of the corporate debtor. You know, corporate debtor, you also kindly see, on the one hand, at his own, he is filing the liquidation petition.
He has filed the liquidation.
My lord, at his own, and in the form itself, you also will see,
Mhm.
there is a provision that whether the committee of creditors meeting, etc., he has said not applicable.
Creditors, we are
I'm-
talking of
I'm sorry.
protecting the right of debtors.
I'm sorry, I'm sorry.
So how the committee of creditors is
My
concerned?
lord, my lord, the question is, my lord, the persons here it says that he will benefit of the corporate debtor.
Yes.
Now, there are persons who are the bank, etc. Well, they are creditors.
Who?
The bank.
I'm not the bank.
He is representing the company in distress.
The company distress, he is acting on behalf of the committee of creditors. Well, the committee of creditors are there who are
Who has appointed the resolution professional?
because they are insolvency process. The committee of creditors are there who are entitled for the money.
Right.
And corporate debtor is
Who appoints the resolution professional?
not professional. Now, here is that for the benefit of the corporate debtor.
Yes.
Now, whether he is acting on behalf of the corporate debtor when he filing the.
Let's read his pleading.
Lawsuit,
Let's read the pleading.
lawsuit.
Yes. Read, Mr. Counsel.
And when he has filed the liquidation, it is not in the interest of the corporate.
That
debtor.
fact is presently that fact is not on record.
As far as liquidation order, let me revert on that. Your lords, as per law, I am required to file because there was no stay by this court during that time. By law, I was required to file application for liquidation.
No,
Otherwise,
he cannot file it as per 2. He
Lord,
cannot file it without the minute of the
since-
66% voting.
your lords, since that CRP period had expired, your lords, I had no other option but to file an application for liquidation. And by law, I was required to file. Hence, I had filed the liquidation application.
Okay.
That is,
So read yeah, that you are acting on behalf of the corporate debtor
please, your lords.
in your appeal.
Your lords, in the memo of party itself, I've mentioned that resolution professional of corporate debtor RSH Agro having office as this. Yes, your lords. This fact is not disputed, your lords, that I am not the resolution professional. Till date, till the time that another liquidator is
Okay, so
appointed.
what is your legal ground of challenge to the impugned order? Come to that now.
Please, your lords.
Yes.
Your lords, should I argue on merits, your lords?
Yes, of
Please,
course.
your lords. Your lords, I had provided a list of dates for a brief
Yes.
background.
Yes.
I had given 2 copies, your lords. Both my lords have copies. Yes.
Yes.
So serial number 1, 5/8/2019, your lords, section 12 was amended, thereby extending the time to 330 days period, your lords. The CRP period. Initially, initially it was 180 plus 90, then amendment was granted and then 330 days. 15/11/2019.
Mr. Rao, are you ready to argue on merits?
No, I'm not.
Hmm?
I have no problem, my lord, because the
All right.
the only thing which I was submitting for lordship, my lord, that subject correction, that once he has accepted the judgment of the single judge, how that can be assailed?
Acceptance, how do you say?
You know, that filing of the liquidation petition itself,
That was the direction given by the single bench.
no, single bench may not, did not extend it. Now the
Extend the time.
extend time. Now liquidation proceeding can be filed only when the time period expired. And he himself says that after the judgment of this honorable court, the single judge, the time period is expired. And thereafter he filed the liquidation petition.
And he is asking for extension of time, basically.
He, before the, earlier he paid for extension of time.
Who filed the writ petition?
This petition was filed by one of the, my lord, the corporate, the creditor. who was-
Creditor.
My lord.
One of the
For-
financial creditors
Praying for
Praying for the extension of time should not be allowed.
should not be.
should not be allowed. All right.
For setting aside the order of NCLT granting.
yes.
extension.
Now, question is that, my lord, you'll also see the list of dates which have been given in the writ appeal.
Yes.
Writ appeal with us. You'll also look into
Roman number 4, your lords.
at the list of dates. Para page 5, my lord.
Page 5.
Page
List
5
of dates in this appeal.
in appeal, my lord.
Okay. He has given a summary thereof.
Somebody is thereafter the Guwahati High Court so-and-so was pleased to set aside in his order so-and-so and CRPC and hence the purging appeal. Now, in the appeal before the application before the for liquidation, you'll ask me, I will get the copy, my lord.
Yes, please.
Can I have a copy, please?
This is your application.
But I was not aware that you will be filing it application.
I'll give it to my copy.
The application is by you.
Please, your lords, but I was not aware that they'll be relying on that.
Then
But this is mentioned in the appeal, my lord. This is mentioned in the appeal, the liquidation.
in the appeal that he has filed the
Ah.
liquidation application.
I'm not saying anything, my lord. You'll also see the synopsis itself at page 2, last but one paragraph, my lord.
Synopsis, yes.
Thereafter, Guwahati High Court was pleased to set aside the order passed by so-and-so, which CRP was extended so-and-so. In view of the above, the time period for CRP extends expired on 28/2022. Therefore, in terms of it is necessary that the order of liquidation.
So that is by legal implication that he is forced, compelled to file the application.
My lord, once it is filed, assuming, my lord, I am a subject, my lord, that today he is coming up again challenging this one. He has filed the liquidation petition there. Now liquidation order is passed. Then what will remain? And
Right.
once it is assuming, you know, this honorable court by satisfying, you know, the allows the appeal. Now what will happen to liquidation?
Liquidation process.
Can, you know, both the things go together? He has to take a decision either to seek relief from this honorable court or to go for the liquidation.
Right.
He is going both sides. He is going for liquidation. He is going for writ appeal, and that too without authorization. When bank was party to liquidation, they are not coming up.
Your lords, that let me revert on that, your lords. As far as that liquidation, your lords, your lords had passed the order of status quo. So that liquidation order is stayed as on date. The liquidation proceeding has stayed. Because anyways, because my grievance was if the liquidation order is passed, this appeal become infructuous, your lords. Hence, your lords had passed an order of status quo, your lords. That some was my arguments regarding the liquidation application, your lords.
I'm not on
Your lords, as for list of dates, your lords, on 15/11/2019.
Status quo is basically qua the property, the order has not been stayed.
Yes, your lords. There is status quo order which is operating. So liquidation proceedings are anyways not proceeding ahead.
That may not
Please,
proceed, but well, that may not
See-
proceed. But the question is that, my lord, when coming before the appeal, you'll also hear, my lord,
Let the arguments be advanced on entirely on merits.
Please, your lords.
Piecemeal arguments would not serve the purpose. Argued finally when,
Please, your lords.
argue the matter
Please, your
finally
lords.
then
Yes, your lords.
on a suitable
On
date.
15, yes, your lords.
Yes.
On 15/11/2019, your lords, the
Yes.
Supreme Court, in judgment of Committee of Creditors SR Steel, struck down the word mandatorily from the section 12 and also held that time beyond 30 days extension can be also granted. That was held by Supreme Court, your lords.
Yes.
Your lords, as far as coming to this matter, your lords, on 23/11/21, your lords, NCLT Guwahati allowed application under section 10,
Yes.
which is CIRP proceedings against the corporate debtor itself. On 11/2/22, your lords, NCLT allowed application appointing the present appellant here as an RP, your lords.
Yes.
So the argument that who appointed me as an RP is the adjudicating authority has appointed me an RP, your lords. Thereafter, your lords, RP complied with the provisions of IBC, your lords, and invited in the resolution plans, your lords, upon which he was receipt of 2 resolution plans for the CD, your lords. This is very important, your lords. I have highlighted also in this the list of dates.
Yes.
That it was a receipt of 2 resolution plans. Since the CRP period of 180 days was expiring on 21/5, your lords, in the 7th meeting of COC, your lords, COC resolved to file an application for extension of 90 days under
Yes.
section 12.
Yes.
On 13/5/22, your lords, NCLT wide order date 13/5 allowed the application and extended the CRP
till 28/8/22, your lords. During various COC meetings, the COC members were deliberating on the two resolution plans which were received. Subsequently, there were two revised resolution plans by the same parties, your lords, on 18/7 and 29/7/22. For NK Power Infrastructure and Century Mercantile Private Limited, lords.
Yes.
Since the revised resolution plans were under consideration, your lords, and the amount being invested by them was very huge in the corporate debtor to revive the corporate debtor, during the 14 COC with 87%, your lords, chose to file an application for extension for 30 days. Because on 16/8, before the expiry of the period, which was expiring on 28th of August, RP filed an application before the NCLT, which was well within the time, your lords. NCLT wide order dated 25th August 22, your lords.
All right, come to the orders, merits of the order.
Please, your lords.
What is wrong in the single bill?
Argument, your lords, is the issue of maintainability, your lords. That the writ petition was itself not maintainable in view of the provision section 61, which specifically provides a provision of appeal, your lords. Yeah, kindly have lords.
If the order is without jurisdiction, then
Yes, your lords.
if the order is without jurisdiction, then
Your lords, this is order well within the jurisdiction, your lords, of NCLT, your lords. As per Rule 11, which was provided on the last date, and as far as Section 60 subclause 5, your lords. Kindly have Section 60 subclause 5.
yes.
As the application for extension of 30 days was filed under Section 60 subclause 5, read with Rule 11. Please. Adjudicating authority for corporate person, your lords, Section 60. Subclause 5 says, notwithstanding anything contrary contained in any other law for the time being in force, NCLT shall have jurisdiction to entertain or dispose of any application or proceeding against the corporate debtor or corporate person, or C, your lords, any question of priority or question of law or facts arising out of or in relation to insolvency resolution or liquidation proceeding of the corporate debtor or corporate persons of the under the code, your lords. So under 60 subclause 5, your lords, NCLT was well within its power to grant this. Otherwise, your lords, Rule 11 also gives an inherent power to NCLT to deal with issues, your lords.
You are reading rule. Rule 60.
Section 60, your lords. 60
Section
subclause
60.
5. Yes, your lords.
Yes.
May I proceed, your lords? Because other than this, your lords, Rule 11 of NCLT rules, your lords, is also there.
What does the rule say?
Please, your lords.
Yes.
Inherent powers, your lords. Nothing in these rules shall be deemed to limit or otherwise affect the inherent powers of the tribunal to make such orders as may be necessary for meeting the ends of justice or prevent abuse of process of the tribunal, your lords. So my application for extension of subsequent extension of 30 days was filed under Section 60 subclause 5, read with Rule 11. So my first and foremost argument, your lords, of the maintainability of the writ petition, your lords. In my grounds, your lords, the single bench has not dealt with the issue of maintainability in the entire impugned order, your lords. Despite me taking a specific plea in my IA that the issue is not maintainable. Moreover, the writ petitioners, your lords, in the single bench made a false declaration, your lords, before the single bench
Regarding
that they don't have an alternate remedy, your lords. Kindly have para 26 of the writ petition at page number 51 of my appeal, your lords.
Yes, Mr. Saraf, what do you say on this?
That the petition
Why
has
this
no other
argument was
alternate-
not dealt with? Mr. Saraf,
My lord,
the argument regarding maintainability, then a single bench failed to consider that.
my lord, you also see,
Is a mandatory statutory remedy available to you? Then go to the NCLT rather, yes.
this order, when prima facie, you also be aware, my lord, when it is without jurisdiction.
Same, that is permissible.
No.
65, read,
No,
please.
65 will also see what is said.
Read.
What is single judge clearly said.
Kindly read 60 subclause 5.
Subclause 5, my lord.
Yes.
My lord.
Any question of priorities, any question of law or facts
My lord,
arising out of
notwithstanding
or in relation to insolvency resolution liquidation.
any question of priority or question of law facts arising
Yes.
out of relation to insolvency resolution process. My lord, when there is a specific bar in section 12,
All right, so it's an illegal order. It's an illegal order, plain and simple.
my lord, without jurisdiction means, my lord.
No, it's
Your lordship,
not without, it's an illegal order.
Your lordship, just-
Yes, yes.
When some act says, my lord, specifically 12,
It can't do, it can't extend beyond that.
After one cannot be passed.
So the order is illegal on the face of the record.
Then what will you?
So then the remedy is there. Why a writ jurisdiction, please?
Once the jurisdiction has been exercised, your lordship may say.
Is immaterial.
I will place, lordship will place, next judgment, I will place before the Supreme Court. The judgment.
Wrongly exercised jurisdiction.
Wrongly exercised jurisdiction.
The Supreme Court recently, Southern East, Southern.
I have provided a copy of State of Madrasa versus Great Ship India Lodge.
This is
I've just provided
the
copy.
water thoroughly judgment for
Specifically dealing with this alternate remedy issue.
Very decisions have been number of lordship is also considered in the surface matters also.
Yes, so why should we entertain?
Para 14 of this.
Para 14.
Para 14.
Read.
At the outset, it is required to be noted against the assessment order passed by assessing officer under provision of MV Act says the assessee straightaway preferred a writ petition under 226 of the Constitution. It is not in dispute that the state statutes provide for a right of appeal against the assessment order passed by assessing officer and against the order passed in first appeal authority and appeal revision before the tribunal. In that view of the matter, the High Court ought not to have entertained the writ petition under 226 of the Constitution.
There is a recent judgment
Yes,
now.
Lord. This is a recent judgment, Your Lord.
2023, this is
22 minute, 23 judgments is there.
23 judgment. You have a look at this one, sir. The Supreme Court came down heavily on the High
So
Court.
that is on the surface act, my lord.
Yes.
So far as after that, my lord, after that in the taxation matter itself, with the border salary, my lord, the apex will be clarified.
Read these judgments, sir, please. This
Recently,
takes
Delhi
care of
High Court
everything.
Division
This
Bench
is
has
surface, my
also-
lord. I think.
Immaterial, it's on principle, sir.
Punjab, Haryana, my lord, the court.
It's on principles.
I've seen, my lord, that one, Punjab, Haryana and all those judgments.
So why the writ? Then above all, sir, the issue is that if an objection was raised, learned single bench was required to consider.
Lordship is asking to say that this may be
Your
considered not
Recently, also, Division Bench of Delhi High Court has also dealt extensively with the issue of alternate remedy. Your Lord.
Alternate, why you go to Delhi High Court, there are Supreme Court.
There are Supreme Court judgment. Where is your pleading regarding maintainability?
Please, Your Lord.
Read.
Your Lord's IA 305, which is 199, 200.
Page 200.
200, Your Lords. I filed an IA in the writ petition, Your Lords.
Yes.
Your Lords.
Read,
Kindly have page number 20210, Your Lords.
Yes. Read.
Grounds.
Yes.
The reviewed order decision is not even wrongly decided by NCLT. The same can be assailed before the appellant forum in terms of IBC by opposite parties, but not under jurisdiction of 226, Your Lords. Next page. IBC is a single unified code.
Here
covering
it
the
is a
entire
specific argument, sir.
Please, Your Lord.
Specific objection.
Give me one day.
Sure, definitely.
Examining the
Dr. Saraf,
alternate remedy,
for time to address the court regarding
alternate remedy, my lord.
issue of maintainability of the writ petition
On the
raised by the plaintiff's counsel.
My lord.
The status quo order shall, oh, it's already confirmed, list after 4 weeks. As per it.
So short date will be given, Your Lords. in this-
You are already enjoying the status quo. What is the problem?
Because the value of the liquidation value of the company decreases, Your Lords, as the time passes. Your Lords.
Otherwise also now gone.
Please, Your Lords. Please,
We'll see 4 weeks next.
Again, the RP is interested. My lord, RP, according to me, my lord, he cannot be interested.
To bring judgments, RP can't file. You also bring judgments on the next day.
Please, Your Lords.
Yes.
In fact, he should be removed.
File the application before the
My
NCLT
lord.
for his removal.
Item number 11 passed over.
Give these back. ये वापस दे दीजिए. Yes.
My lord, in this case, my name has not been reflected, my lord, as respondent. So lordship may kindly take up on Friday, the brief, my lord, I did not carry to them.
List on Friday after disclosing the name of. It's already there.
My lord,
Talukdar,
My lord, no, my name is not reflected in the cause list, my lord.
in the
SK
call list,
Talukdar.
after reflecting the name of Mr. Talukdar,
SK Talukdar.
SK Talukdar as Standing Council Corporation
My
Department
lord, on
in the call
Friday.
list. On Friday.
Oblige.
Item number 28 passed over matter.
28. Yes.
Please, your lordship. My lord, this appeal is directed lordship against the judgment of the Honorable Single Judge Lordship by the order dated 8/12/2022 lordship. Lordship, by which lordship the writ petition of the respondent number 7 of present.
Who is there for respondent number 7?
7, no one appeared lordship, but service already complete lordship. Because lordship, there are no case at all, lordship. Because lordship, I was appointed in a specific lordship, center lordship. But she submitted that I was appointed against the lordship Bisingsa part 2 lordship Anganwadi center lordship. But in my appointment order, it is clearly reflected that lordship I was appointed in Narayanpur part 2 Anganwadi center lordship.
So your appointment has been interfered by single bench.
Not directly interfered, lordship.
Then,
but the observation was given, lordship, that I was appointed in the Bisingsa part 2. Whereas, lordship, because lordship, at the time of hearing of that writ petition, lordship, I was not able to appear before the London.
no, like no one appears for this point number 7 despite service. The writ petition, the writ appeal is thus admitted. Admission notice as the government counsel, as additional senior government advocate MS Bhattacharya appears for the response number 1 to 6. Thus, notice need not be issued to such respondents. However, steps be taken for effecting service on the response number 7 post admission within 7 days. Whereafter, notice be issued to such respondent. The ad interim order dated 9/2/2023 is confirmed to last till disposal of the appeal.
I look like it.
The number 59 of supplementary list.
59. Yes. What is it about? Who is there?
I'm for a state, madam. I'm for a state.
We understand. Who is for the review applicant? Is it PIL
It's a PI.
or orders? What is the PIL about? Non-implementation of section 12(1).
Lordship, on the last occasion, Lordship had passed orders to the Secretary Education to ensure admission of these 49 children whose.
What has happened, Mr. Counsel?
Yes, madam. For that, madam, I need some time, madam. Today I have contacted the secretary, madam. So I could not get the entire information today, madam.
Lordship, I have some information. Out of 49 children, 15 children have been admitted in Nagaon and 1 in Guwahati. That is the only thing, and they have done it on because they got the information through the social media and other.
You have not communicated the order.
We have communicated. We have communicated.
You have communicated.
Yes, madam.
Then
But the schools have told
what
us
steps
that
they have taken,
not
madam?
received any information from the.
so all right, 7 days time.
Yes, madam.
7 days further opportunity is given to the
Lordship-
council, Mr. So and so,
Lordship, I pray that the other remaining children get the admission, Lord,
to ensure compliance of the directions given by this court
on
on
10/4, Lordship.
12th April. List on 17th May.
Oblige, lordship.
Much obliged, Lordship.
Done. Yes, now we have that additional supplementary list at 3:30. Okay. Very well. Yes.
The numbers 34 to 46.
Senior counsel, Mr. Mishra is unwell. He's suffering from fever. So if any reply is required, he can come on Wednesday, madam.
In the meantime, let the other counsel argue. He has completed his arguments.
Madam.
Basically.
Please, your lordship, before I commence, I would like to clear 2 things. On the last occasion, your lordship was disappointed. I was not present.
Yes.
Because I was under the impression that there was one more criminal appeal of Niranjan Hujai. I thought that he will be leading. But anyway, I will be today doing, and I was on leave, my lord. And second, your lordship has put some queries.
Can't be on leave. There is no
Well,
such, you are not a civil servant.
Some other matters were there outside.
So you have more priority to other matters rather than.
No, my lord, it's not like that.
Division bench of the Guwahati High Court where Chief Justice is sitting.
No,
You know,
not
like,
absolutely
you
not.
need to take care of that thing now.
My lord, your lordship has put some queries.
No, you forget about the queries, you argue your matter.
I thought
They have no queries, they have just casual banter, nothing beyond that.
My lord, the appeal that has been.
You are representing?
I'm representing Jewel Gallosa, my lord.
Yes.
who is behind the bars. And I will be representing one more accused, Arsing the Warisa. He's on bail.
Okay.
My lord, your lordship, I have challenged the judgment of 22/5/2017 passed by the Learned Special Court, wherein I was being convicted for life imprisonment
Yes.
under section 16 of UAP Act and section 17 for RI for life and section for 10 years for section 20 and 5 years for 25(1)(d) of the Arms Act and 10 years for 120B IPC, my lord. My lord, I have given a sequence of events because since I made 2 copies. Your lordship, I have arranged the sequence-wise date in this matter. I will be going through it. I will just give a.
We should issue a certificate of appreciation in
No, my lord,
advance.
I'm just.
Then we have seen that.
Yes.
Proceed.
My lord, my arguments will be, I will be impugning the judgment on 5 heads, my lord. First, I will go with the sequence of events. Then I will take to the filing of the charge sheet, what they have leveled against me in the charge sheet. Then the charge head, the framing of the charges. Fourth will be, your lordship, the role attributed by the Learned Special Court against me, basing on the evidences. Fifth is the analysis and the findings which has been recorded. And the sixth will be, your lordship, the grounds on which the matter will be, I will be canvassing.
Okay.
Your lordship, kindly come to Exhibit 36, my lord, in volume 1 of the paper book, my lord.
Here that list the summary of exhibits. Yes. What is that supposed to be? FIR.
FIR, my lord.
Yes.
Your lordship will.
No, this is evidence. Exhibits.
Exhibit 61.
61 or 36?
My lord, 36, page number 61. Evidence.
Upam, the list of exhibits separately. Yes. FIR is not a part.
36. No. I'm talking about the FIR is 36. I'm coming from that.
FIR number 36.
Exhibit 36, my lord. Your lordship will kindly come to page 61. My lord is there. Your lordship will find the FIR was registered on 1st of April 2009 in Basista PS under section 120B, 121, 121A of the IPC, read is section 25(1)(b)(a) of the Arms Act.
Exhibits. Yes.
Your lordship. The contents of the FIR will kindly come to page 63.
Yes.
To the officer in charge, Basista PS, FIR Basista PS, reference was made to a GD entry 1162 dated 1st of April 2009. Sir, with reference to the above, I beg to report that on the basis of specific source information today, on 1/4/2009 at around 4 p.m., vehicle number AS01AH1422, Scorpio and number AS01L0609 Tata Sumo were intercepted at 14 Mile GS Road. And on charge of the vehicles, the following persons suspected to be cadres and linkmen of DSDJ organizations were found occupying the vehicles and from their possession a sum of ₹1 crore meant for purchasing sophisticated arms ammunitions to wage war against the state, as well as to carry out their nefarious and illegal activities. along with 2 pistols and other documents, including blank letterhead of DSDJ, were recovered, which were seized accordingly. I therefore request you kindly to register a case under the proper section law against the accused person and investigate into. The persons who have been apprehended, my lord, it is Projendra Hujai and Babul Kempai.
Yes.
And the FI was registered as Basista PS case 170 of 09. Now,
Yes.
at page 64, your lordship, this is the seizure list, search and seizure list was given into effect. Here, I'm going through the seizure list, my lord.
Yes.
I see SI Moizuddin Ahmed of Basista PS. Your lordship, kindly note the search and seizure at 14 Mile on GS Road.
Yes.
ICSI Moizuddin Ahmed of Basista PS do hereby seize the intercepted vehicles bearing registration number AA01AH 142 Scorpio and AA01L0609 Tata Sumo at the above noted place, and on search of the vehicles number AA01AS1422, occupant Projendra Hujai with driver Bunu Sonar are found, and on search of the belongings found 2 pistols in a briefcase along with other documents, and on search of vehicles number A01L0609, 4 occupants, Babul Kempra and driver Dipankar Deka, and 1 big airbag containing huge amount of money reportedly kept by Projendra Hujai, occupant of Scorpio number A01AS1422, are found, and all the recovered items are seized in connection with the above noted referred as above noted case as described below in presence.
Where did you read the word case from?
Pardon, my lord?
Where did you read the word case in this line? Is it there?
Seized in connection with the above noted.
Reference. It's REF.
REF reference. Sorry, my lord. Reference as described below in presence of undersigned witnesses.
Yes.
Now, the signed witnesses Projendra Hujai, my lord, Babul Kemprai, and
They're not the witnesses.
my lord, these are the accused persons.
Yes.
Bunu
From whom seized?
Seized.
Yes.
And signature of witness, Panchnama, your lordship,
Yes.
which they have given effect on page 65. They have taken the signature of Bunu Sonar and Dipankar Deka.
Yes.
Now, your lordship will kindly see in the description of seized articles, my lord.
Yes.
They seized the vehicles, both the vehicles, my lord.
Yes.
Kindly come to serial number 3. 1 American tourister briefcase containing documents including 3 sheets of DSDJ letterheads, which are blank, my lord, blank, and a letter written by Mohit Hujai, Chief Executive Member, NC Hills,
Autonomous.
Yes. Council, addressed to Superintendent Engineer PWD RNB NC Hills, Haflong, to issue work order in favor of Sri Projendra Hujai
Of the amount of
rupees 88 lakhs.
Yes.
4th seizure was the 7.65 mm pistol.
Yes.
5th was 1 pistol marked 9 mm pistol red in made in China.
Yes.
With 1 magazine and 5 live rounds. 6th, 1 arm license issued in the name of Sri Projendra Hujai, son of Sri Satya Hujai of Sarat Nagar, PS Haflong, District, NC Hills, Assam, bearing license number 1576 NC, valid up to 31/12/2009, issued by DM NC Hills, Assam. 1 armed license bearing jet and number 17382-89 in the name of Projendra Hujai.
Yes.
8 is the Sony Ericsson mobile number, my lord. Mobile. 9, 1 red and black color big size airbag. 10 is 3 lots of containing 10 bundles.
Yes.
In each lot of 1,000 denominations, Indian currency note, total 30 lakhs.
So like 10, 11, 12, 13,
yes,
14, they are all currency notes.
All currency notes.
Yes.
Now, in this scissor was given effect
on
Yes.
1/4/2009, my lord.
Yes.
And it was a basically Panchnama, my lord. The seizure witnesses were Bunu Sonar and Dipankar Deka.
Yes.
Now, on 1/6/2009, my lord, 1/6/2009, the Ministry of Home Affairs directed the NIA to take over the investigation of the case.
1/6.
1/6/2009.
Right.
Your lordship will kindly find that order which has been exhibited as 462. Exhibit 462 in volume 8.
Volume 8. Remember.
Volume 8. Volume 8.
Page 71 in your compilation. Yes. Yes, yes. Right.
My lord is there.
Hmm.
I'm reading in my lord. Whereas the central government has received information about the commission of offences under section 120B, 121A of IPC, and under section 25(1)BA of the Arms Act, in respect of which crime number 170 of 2009 of Basishta PS and 3/2009 of Dunmangar Police Station in the state of Assam have been registered. And whereas the central government, having regard to the gravity of the said offences and other material in its possession, is of the opinion that the said offences are scheduled offences under the NIA Act and offences connected to the scheduled offences under section 8 of the said Act, affecting the security of the state and hence should be investigated by the NIA. Now, therefore, in exercise of the powers conferred by subsection 5 of section 6, read with section 8 of the NIA, the central government hereby suo motu directs the NIA to take up the investigation of the aforesaid case and such other offences as may come to light during the investigation. This order was been exhibited as exhibit 462, my lord, by the prosecutions. Now, the appearance before your lordship, I was apprehended in Bangalore on 3rd June 2009.
Bangalore.
Bangalore.
After the registration, after 3rd June,
3rd.
you were not arrested when the seizure was made.
No.
Okay. Okay.
The FIR was lodged on 1st April, my lord.
Right.
Seizure was done also on 1st April with respect to the 3 letterheads of DSDJ.
Then they were let free. What happened?
Then the NIA, the MHA
You
passed.
see, just hold on.
Hello.
The FIR indicates offences under section 121, 121A.
My lord.
So the IO did not, the seizure officer did not arrest them.
No.
They were let free.
No, they were arrested, my lord. They were arrested.
From, you are saying from Bangalore?
No, I was arrested from Bangalore.
I means who?
Me, the appellant, the Jewel Gallo.
Carlos,
Yes.
he was there at the spot.
No. I was not there at this spot.
1/4/2009, Jewel Carlos was not there.
No.
How does he sign the memo then? Acha, that is Fozendra.
Fozendra and Babu, my lord.
Oh, okay. Okay. Yes.
On 1/4/2009, the FIR was registered.
Yes.
And on 14th mile GS Road, the prosecution case is that they apprehended
Yes.
Fozendra and Babul Camprai for 14 mile GS Road
Right.
and gave effect to the seizure list and the Panchnama, my lord. From their possession, 3 letterheads belonging to the me, DSDJ. And on 1/6/2009, the MHA transferred the matter suo motu to NIA.
NIA, yes.
I was apprehended by the Assam police on 3/6/2009 with co-accused Arsinda Varisa, my lord, and one more witness accused was there, Samir, who pleaded guilty and he was
let off.
Yes,
On sentence undergone.
Under section 19, 3 years period undergone. Now, on 5/6/2009, your lordship, the NIA re-registered this case.
Okay.
Which is at exhibit 461 at page number 170 of volume 8.
Okay. Yes. Then,
my lord. Now, on 6/6/2009, your lordship, yes, there are certain court's orders of the special court of the court below, which I would like to
bring on your lordship may draw the attention.
Hmm.
What happened on 6th June 2009, the NIA prayed for tagging the FIR, other documents and property of Basista PS case, which was been given effect on 170 of 2009 with NIA case 1 of 2009. And second pair was that the apprehended accused persons, me, Arsinda Warisa and Samir, be given for 14 days custody for taking
Remand.
Remand for there was
Investigation.
specific reason was that for recovery of arms and ammunition, cash, and to carry out scientific investigation only. The CGM by order dated allowed both the pairs, my lord, on 6/6/2009, my lord.
Okay.
Now, on 11/6/2009, the IO of the NIA, the investigating officer, he made a prayer before the CGM court for addition of section 17, 18, and 19, which was allowed on 11/6/2009. On 15/6/2009, my lord, the CIO produced the co-accused Samir Ahmed for recording his confessional statement. And on 16/6/2009, his confessional statement was being recorded. And here I am not raising this issue whether he was being given time or not, because that's exculpatory only, my lord. He has put the entire thing on us. Now, on 19/6/2009, we were produced before the court because of our remand period. Then on 13/7/2009, your lordship, that is a very interesting thing, which though I will come on elaborately, your lordship will kindly see peruse exhibit 117 at page number 660 of volume 3. That is one of the piece of evidence which the NI prosecution claims that it was a disclosure statement made by co-accused Arsinda Warisa. In that disclosure statement, the Warisa gave email IDs to the investigating officer, and on the basis of those email IDs, they could find that certain communications were done by me, that Jewel Garlusa, with NDFBS. That is one organization, band organization. Now, that disclosure statement, your lordship, before I take it, your lordship, just 13/7/2009, the investigating officer who recorded it, he has recorded it that disclosure statement was given by Warisa in his custody at the special operating unit of Assam Police. But on record, that by particular day, I was in judicial custody. Arsinda Warisa was in judicial custody. So that piece of evidence we put it before the Mr. IO, that Syam Prakash Pani, who denied it, he disputed it, and then it was later on verified from the CIO, which I will take it on record. So, my lord, I'm just giving a brief. Now, on 13/7/2009, your lordship, the order of the learned CGM is there, which reflects that I was in judicial custody. So, definitely, if I'm on judicial custody, that disclosure statement cannot be there, my lord. Now, your lordship, I overheard it when I was hearing the proceedings of my senior regarding the recovery of 1 crore rupees. Your lordship, there are 2 orders. If your lordship can kindly see those orders, I have asked for the orders. There are 2 orders of 3/11/2009 and 9/11/2009. May I read that orders, your lordship?
Yes, sure.
May I read it, your lordship?
Yes, carry on.
The case records have been put up in view of the prayer dated this day, the 3rd November 2009, made by Sri S.K. Malviya, Inspector of Police NIA, whereby he was asked for a direction from this court so that an amount of rupees 1 crore of rupees seized in connection with this case and is being deposited with the local treasury can be inspected by a team consisting of bank official, local executive magistrate, and personnel from the NIA. The pair is allowed in the interest of the ongoing investigation of the case. Accordingly, the IO is at liberty to inspect the said money in the Kamrup Treasury with his team comprising the said officials for which necessary arrangements may be made from this end. The IO shall ensure that the money after being inspected as prayed for should be retained in the treasury in safe custody until further orders. Inform the treasury officer, Kamrup, district magistrate Metro, and the branch manager SBI Jew Road branch, Guwahati, who are hereby requested to extend necessary assistance to the IO in the above regard. After this, your lordship, there is one more order of 9/11/2009. I'm reading in my note. See, SK Malve being the inspector of police and assistant IO NI New Delhi, camping at Guwahati is present, along with SI of police Sri Bipul Soikia, D10 IC Jorabat outpost, and then IO of the Bosista PS case number 170 of 09, in connection with the order dated 3/11/2009, passed by this court, allowing the said inspector NI to inspect the seized money at the Kamrup Treasury along with his team of officials, and as mentioned in the said order. Sri Malbia as well as Sri Saikia have reported that the original receipt issued by the Treasury officer Kamrup, while receiving the seized sealed trunk containing the money amounting reported to 1 crore of rupees, has been somehow missing, and the Treasury officer now wants that the signature of said original IO, Sri Bipul Soikia, be attached so that he can be allowed to open the said seal box at the Treasury for the purpose of inspecting and counting the money by Sri Malvia and the members of the said team in presence of the Treasury officer. Why I am referring to these two orders, your lordship? The first, the amount was seized as alleged in the prosecution. The amount was seized on 1/4/2009 at GS Road, 14 mile of GS Road, by the police officials of Assam, Jorhat. After the NIA took over the matter, the NIA IO wanted to take over the cash, the seized amount. So he comes on 3/11/2009 before the CGM, and CGM passed the order. When he went to the Treasury office, then I cannot give you until and unless, because the original, the earlier IO comes, and moreover, the Treasury Salan deposit is missing. That definitely they should explain how, where it has gone. So now this order 9/11/2009, it says that there is no Treasury Salan. Now
there could not have been. There could not have been. Treasury Chalan means the amount is deposited in the account.
My lord.
Then only the Chalan is generated.
My lord.
This was lying as cash.
My lord.
So there is no question of deposit.
What I am putting it from their facts, your lordship.
So, people have a right to act foolishly. There is no injunction against that, no?
Because then just such foolishness come very handy to people like us.
Yes.
14 years, 10 years, we are lying behind the bars.
Yes.
That is also an irony.
Some credit should go to the Defense Council also.
My lord. Now, your lordship, 15/11/2009. Now, my lord, this particular, I will come to the observation memo where the amount has been gone down by 5,000-6,000 rupees. That I will come in during the evidence part. Now, in sequence wise, 15/11/2009, my lord, the prosecution sanction order under section.
So when was the amount handed over? Actually, the amount was handed over to NIA on what date?
My lord, the order sheet does not reflect that.
And when was the amount deposited with the treasury? What is that date?
The lordship, that
1/4/2009 to November 2009.
My lord.
Where was the amount lying?
My lord, in observation memo,
dated
in compliance to the. Yeah.
What is the date?
My lord, observation memo where the counting was done, it was done on 10/11/2009 in the SBI branch.
Question, very simple question is put to you, sir. What was the fate of the currency notes between 1/4/2009 till November 2009? 10 years was not a time enough to find out about this fact.
My lord, the query was put on up to us on 313, my lord. With respect, we have explained that I was never seen the currency notes and all. But your lordship is correct. Agreed. The amount
Query is being put to you to find out whether you know what happened to the money after 1/4/2009. Where did it go? Or was it lying in the IO's house? Is there any corresponding document?
there's no corresponding documents, my lord.
Did you put any question to the seizure officer of Basist police station?
My lord, Moizuddin Ahmed.
Yes. So now you will be preparing the case on dais.
My lord.
Is that right?
Yes, you're absolutely right.
So now who is to blame for these 10 years now? When the defense counsel says,
My lordship.
when the defense counsel says, I'm standing here arguing the matter, though the accused is in behind bars 14 years, now I'll be preparing it on the dais.
Absolutely correct. Your lord. Now your lordship will kindly come on 15/11/2009.
You've not got our answer till date, till now.
Moizuddin Ahmed, your lordship, he was being cross-examined, my lord.
We need an oral answer. Was any step taken by the IO or the seizure officer? How did he deal with the currency notes? He couldn't have left it lying around.
My lord, the Bikul Saikia, the IO of the case, he has about the amount cash was being seized by Moizuddin Ahmed and it was handed over to Bikul Saikia.
Yes.
The PW 145 and he re-seized it. The cash money seized were deposited to the challenge after receiving the order from CGM. That is it come up in chief.
Okay, very well. Carry on.
Volume 6 division. Volume 6. Volume 6. Exhibit. Volume 6. Exhibit. My lord, on 15/11/2000.
Yes, yes.
My lord, on 15/11/2009, the NIA got the prosecution sanction. On 17/11/2009, the NIA filed the charge sheet against 14 accused persons. Under section 120B, 121, 121A of IPC, and 16, 17, 18, and 20 of UAP Act. Read with section 25(1).
Yes.
Now, the court below takes cognizance of this matter on 17/11/2009 in this matter. Now, on 19/10/2010, the NIA files a petition for joint trial of NIA case 19 and 29, which was rejected by the court below because the court found that there are two sets of
different sets of incidents, right?
Now, but subsequently, your lordship, on 1st August 2013, the trial was clubbed.
Okay.
Technically, it amounts to a review, but was not being challenged. Now,
so judgment is common? No.
No.
So the trials were not clubbed. The cases were tried.
Jointly tried.
The cases were tried on the same dates, but the judgment was sent.
Different.
It was a different, separate judgment. So it's not clubbing. It's basically parallel running of the cases.
Joint trial, it has been reflected in the order sheet, my lord.
It's not a joint trial. Joint trial would have resulted into a single judgment.
Single judgment.
Yes.
Now, my lord, on 4 August 2012, my lord, the special court framed charges against us.
Yes.
Now, your lordship will kindly, I will take through those charges first.
Yes. Would you like to read it from the judgment or from the charge?
No,
itself?
from the charge, your lord.
Volume
Volume 1, my lord.
Volume 1.
Volume 1.
The charges are identical for every
Identical.
accused. Charges are identical.
Identical, my lord.
Okay. Volume 1, part.
Page number 4 to 6.
Not in this. Volume 1, part 2. Volume.
No, my lord, it is volume 1. Paper book 1. Paper book volume 1.
Paper book volume 1. This is paper book volume 1. The exhibits, not the exhibits.
No, not the exhibits. It is paper book.
Paper book. All right, you read. We'll take out from the judgment. Come. You read. Charge to reproduce kiya hoga na. Other charge has not been reproduced in the judgment. Okay. Read.
My lord, 9 accused persons' names have been given, my lord. You have charged them. First, that you, after forming terrorist gang DSDJ or Black Widow in 2004, and particularly during the period of January to March 2009, entered into agreement with Ridal Hussain Khan, Jayanta Kumar Ghosh, Karuna Saikia, Devasis Bhattacharjee, and Sandeep Ghosh to do illegal act or an act which is not illegal but by illegal means. That is to raise fund for a terrorist gang by siphonning government fund, convert Indian currency to US dollar, to procure arms and ammunition to wage war, cause death of innocent persons, terrorize the people and extorted money, kidnap for ransom, disrupted works of God's conversion and construction of east-west corridor of 4-lane national highway, etc., and thereby committed an offense punishable under section 120B IPC and within my cognizance. Second, you after forming the said terrorist gang in 2004 entered into conspiracy among its members to wage war against the government or attempts to wage war or abets the waging of such war, and thereby committed an offense punishable under section 121A IPC and within my cognizance. Third, you after forming said terrorist gang in 2004 wage war against the government by procuring illegal arms, killing innocent persons, disrupts development activities such as God's conversions, construction of 4-lane highway, captured administration of NC Hills District Council by overweighing elected CEM Depolal Hujai under threat to life, etc., and thereby committed an offense punishable under section 121 IPC and within my cognizance. Fourth, that you being a member of Dima Halim Dauga, in short DSDJ, a terrorist gang, did terrorist acts by killing 10 innocent truck drivers in May 2008, 7 CRPF personnel and 7 Assam police personnel in 2008, disrupted development works such as God's conversion, construction of east-west corridor, which are essential service to the life of the citizen, kidnap and abducts person for ransom, overweight elected CEM Dipolal Hujai of NC Hills District Council in January 2009, etc., and thereby committed an offense punishable under section 16 of the UAP Act and within my cognizance. Fifth, that you after forming terrorist gang DSDJ in 2004, directly or indirectly involved raising and collecting funds or attempts to collect funds by extortion, kidnapping, chiffoning and deflection of government funds through Mohit Hujai and others, and in committing such activities kidnapped R.S. Gandhi and realized 4.5 crore chiffon government fund with the help of R.S. Khan, Karuna Saikia, Jayanta Kumar Ghosh, Devasis Bhattacharjee and Sandeep Ghosh by paying money without supply or short supply of articles, making the rate of supplied articles more than double of market rate by preparing false bill, vouchers, delivery challan, money received, etc., and thereby committed an offense punishable under section 17 of the
Mr.
UAP.
Burgoyne, is there not a conflict of interest when you are representing them? On the one side, you are representing NHA DCL, and on the other side, you are representing the people who are obstructing that very work. Is there not a conflict of interest?
My lord, to the best of my knowledge, my lord,
Carry on.
Sixth, that you are forming, after forming terrorist gang DSDJ in 2004, conspires, attempts to commit or abets, advises, incites, directs for commission of terrorist act, or did perpetratory act such as raising of funds, conversion of Indian currency to US dollar to procure arms to the commission of such terrorist act, and thereby committed an offense punishable under section 18 of the UAP Act and within my cognizance. 7, that you being a member of Dimahalin Doga in short DSDJ involved in terrorist act as mentioned in the foregoing head of charge in court, yet and thereby committed an offense punishable under section 20 of the UAP and within my cognizance. 8, that you, after forming Dimahalin Dauga in short DSDJ, a terrorist gang in 2004, purchased illegal arms and ammunition from the international market, particularly the Cox's Bazar of Bangladesh, and brings into Indian Union in contravention of section 11 of the Arms Act, and thereby committed an offense punishable under section 25(1)(d) of the Arms Act and within my cognizance. And I direct that you be tried by the said court.
Which is the paper book containing 313 statements?
My lord, 313 statements. My lord, it is there.
Which paper book?
Volume 5, paper book.
Volume 5 there. Yes, carry on. You carry on at your own pace.
Your
Yes.
lordship, what I want to make a short submission is that before I go into this, the analysis and findings, the main question one arises is that whether the sanction under section 45, which has been accorded and the court took cognizance, whether it was done as per the procedure, my lord. And your lordship will kindly appreciate that as far as section 45 is concerned, my lord.
Yes.
My lord, kindly.
Yes,
My
carry
lord,
on. Yes.
What my humble submission is that before we go into the merits of the trial of the matter, the lordship, the first one question was that we raised the question that the cognizance, the prosecution sanction accorded by the sanctioning authority is a mechanical one and is not a non-application of mine. The lordship will appreciate that prior to the Unlawful Activities Prevention Act, there were two earlier acts, that is TADA and POTA, which are more of a draconian act, my lord, which have been repealed. And after that infamous Mumbai incident, terrorist strike, the UAP Act was being amended, my lord, in 2008. And this particular provision, section 45, was being inserted by the Amendment Act of 2008. Now, your lordship will kindly see in section 20A of the TADA.
Yes.
This now.
Yes, yes.
My lord, if a lordship sees on section 20A of TADA, there it starts with a non-obstant clause saying that anything in the court, no information of the commission of an offense under this act shall be recorded by the police without the prior approval of the district superintendent of police And second, no court shall take cognizance of any offense under this act without the previous sanction of the Inspector General of Police, or as the case may be, the Commissioner of Police. Now, what happened, Your Lordship? In TADA, as far as TADA is concerned, no police officer can register a case without the approval of the Superintendent of Police. And no court can take cognizance without the approval of the district magistrate. Now, after TADA was been repealed, Your Lordship, POTA came into existence, my lord.
Yes.
Here, my lord, section 50 of POTA, Your Lordship.
Yes.
Here, instead of the center, what the Indian government did was that instead of the restricting it to the district magistrate and the Superintendent of Police, there it came that it will be the central government or the state government. No court shall take cognizance of any offense under this act without the previous sanction of the central government or the state government, my lord. Now, after the POTA went away, my lord, now in the Amendment Act,
Yes.
Your Lordship will kindly see at page 100 in that the
Yes.
notes which I have given.
Yes, yes.
Your Lordship will find section 13, amendment of section 45, my lord. Section 45 of the Principal Act shall be renumbered as subsection 1 thereof, and after subsection 1 as shown renumbered, the following subsections shall be inserted, namely 2. Sanction for prosecution under subsection 1 shall be given only after considering the report of such authority appointed by the central government, or as the case may be the state government, which shall make an independent review of the evidence gathered in the course of investigation and make a recommendation to the central government, or as the case may be the state government. Now, if your Lordship will see the section 45 in whole, your Lordship, after the amendment,
Yes. Yes, carry on, carry on.
no court shall take cognizance of any offense. 1. Under chapter 3, without the previous sanction of the central government or any officer authorized by the central government in this behalf.
Yes.
And 2, under chapter 4 or chapter 6, without the previous sanction of the central government, or as the case may be the state government, and where such offense is committed against the government of a foreign country, without the previous sanction of the central government. Now, after the amendment, my lord, there was a one protective mechanism was put in that it won't be the central government or the state government automatically granting the sanction, but there will be an independent authority who will review it and they will give a report. And on the basis of that report, the center or the state will take the call. Now, your Lordship will see, I have at page 111, which I have given your Lordship.
Yes.
This is the when the bill was been moved, the maker of the bill, my lord, he has given the Honorable Home Minister at that point of time, he clears the reason behind it.
Sir, just conversations, internal communications.
My lord, there is a now, yes, it is an external aid, but it has been now, law has been laid down that from KP Varghese and all, long time, that normally a deliberation or discussion which is happening in the floor of a house does not come.
Examining the validity or otherwise.
No,
the provision.
My lord, why I'm trying to impress is that if we go after this, if I take you to your Lordship that prosecution sanction order and the evidence of the
authority, which will clearly demonstrate that the order which has been issued for prosecution was totally non-application of mine.
You have to convince the court from the order and the evidence.
My lord.
These discussions would not matter.
No, I'm just
The
wanted
basic
to,
provision is there. You have to tell the court that this sanction does not comply to the provision.
my lord,
Yes.
your lordship appreciate that as far as the word that in section 45,
Yes.
subsection 2,
Yes.
there is a one word is there, specific word. Sanction for another sanction shall be given with such time as may prescribe only after considering the report of such authority.
Yes.
And a report means, if you dictionary meaning, it means it is not a mechanical one. It has to be a thorough deliberation and in written, it has been communicated. My lord. Now, your lordship will kindly come to the prosecution sanction or the lordship. The lordship will kindly find exhibit 301 at volume 6 of the exhibits. There.
Yes.
Volume 6. Page number 1321.
Yes.
Dated 15 November 2009, my lord. Whereas in report of crime number 170 of 2009, dated 1st April 2009 of Basista PS, Guwahati City, Assam, under section 120B, 121 and 121A of IPC and 25(1)(b)(a) of Arms Act that was registered after the search of 2 vehicles at 14 Mile GS Road, Guwahati, and 2 pistols from accused Pojendra Hojai and rupees 1 crore Indian currency from accused Babul Camp Prime, meant for DSDJ, a terrorist gang active in northeastern region, were recovered. The central government, in exercising the powers conferred under section 6(5) of the NIA Act by Ministry of Home Affairs number so and so, dated 1st June 2009, directed the NIA to investigate the above case. The NIA registered the above case as crime number 1 of 2009 under section 120B, 121A of 120 IPC, 25(1)(b)(a) of Arms Act, and subsequently 17, 18, 19 of the UAP Act were added and took up investigation of the case. Whereas the central government, in the terms of the provisions of section 45(2) of the UAP Act and the unlawful activities rules 2008, constituted an authority and referred the case to the authority so constituted for the purpose of making an independent review of the evidence gathered in the course of investigation. Whereas the authority has, after being satisfied on the materials available on the records and on the facts and circumstances stated therein, recommended sanction for prosecution. And whereas the NIA also moved the central government for sanction of prosecution under section 196 CRPC to prosecute offenders under section 121 and 121A of IP. Now, therefore, the central government, in pursuance of section 45(1) of the UAP Act and 196A and B of CRPC 1973, after fully and carefully examining the material before it in regard to the circumstances of the case and the recommendation of the authority as mentioned above, hereby accords sanction of prosecution for offences under section 120B, 121 and 121A of IPC, section 17, 18, 19 and 20 of Unlawful Activities Act, and 25(1)(d) of Arms Act against the accused persons, my lord. Why I'm reading the sanction order, your lord? If we read the sanction order, normally it has been from the Privy Council time, it has been held that a sanction order is the prerequisite for the prosecution to put it before the court for initiating the prosecution, and the court will take the cognizance of the matter. Not the other way around. Now, here, the sanction order, your lordship, must carry on face that there were some application of mind out of facts which constitute the offense has to be there. In this particular sanction order, my lord, which has been exhibited at 301, neither talks about that, but rather it acts as a that authority was there, authority approved it. So the ministry has approved the sanction. Now, if we see the evidence of the witness, my lord, RBS money, and the before we go to that part, my lord, if we see section 40, the Unlawful Activities Prevention Act, prosecution sanction rules, my lord, it says that the moment the investigating authority sends to the authority sends to the investigating agency sends to the authority for according prosecution obtaining opinion, it has to be done within 7 days. The opinion has to come, and after receipt from the 7 day, the prosecution sanction order has to be granted or refused. It has to be come out. That is the mandate of as far as the prosecution sanction rule is concerned. Now, your lordship, if the evidence is it reflects that on 15/11/2009 the sanction order came, and on 17/11/2009 the charge sheet was filed. It has come on the evidence of the chief investigating officer. He says that deposed in the court that yes, in the as far as the prosecution sanction is concerned, after I completed my investigation on 11 November 2009, I sent it to the headquarters, and on 15/11/2009, I get the 16 I get the copy of the order, and on 17 I file it. Now, if your lordship 2009, I was just checking it out. Technically, the authority and the MHA, they get only 3 days working period, because the order which was being communicated on 11, my lord, it goes on 12, and there is Saturday and Sundays come into play, and so technically
They were not taking holidays during those periods.
No?
They were not taking holidays. They were working on the weekends also. This is NIA, sir. Don't expect them to act as any other government office.
My lord.
Yes.
If we take it in that way also, my lord, if your lordship says that, let us presume, I presume it also, that yes, there was an authority was there. Now, this order, the sanctioning authority, he himself come and depose in the court that I have not applied my mind. I don't.
That's a different thing that you read from the evidence.
So
3 days is a long period. What was argued in this court for 5 days would have been finished in 15 minutes. So don't go on these ceremonies. You argue on your merits.
My lord,
yes.
Just as far as the prosecution sanction is concerned, my lord.
Yes.
What I am trying to impress upon this court is that the prosecution sanctioning authority, that is RBS money, who has came to depose the court, he deposed and he agreed to the fact, admitted that he has not brought on record on one basis of which this particular order was been passed. Neither he accepts that yes, he is not aware what documents he have received from the investigating officer. What I want trying to impress is that as far as this order is concerned, it was total non-application of mine.
Okay.
My lord.
Yes.
I will put the judgments on the later court, man. I'm just giving. Second
Have you
aspect.
seen the later judgments on PC Act sanction, the later part of 2000 after 2018, what the judgments say regarding application of mine in PC Act sanction?
My lord.
Have you read those judgments? You may be living in the earlier decades.
No, my lord,
you are talking of challenging the sanction to read the newer judgments of Supreme Court on PC Act.
My lord.
Then you will realize the law has changed for a period of time. It's dynamic. Okay, proceed.
My lord, as far as the second aspect is concerned, my lord.
Yes.
regarding the recovery of these seizure given effect on 1/4/2009 with regarding the place of offense, that is whether it is GS Road or it was somewhere else, your lordship. Now, into that aspect, the trial court relied upon the evidences of the police witnesses, that is 2, 10, and 26, and said that it is.
Mr. Burgoyne, how is Joel Carlos concerned with the recovery? Why you are harping on that recovery?
My lord, these were the facts which the trial court took into consideration and recorded me the conviction under section 120B because recovered 3 letterheads.
Read that part. Only read letterheads.
Only letterheads, my
All
lord.
right, to read that part. And
And
try
a
to convince
recovery
the
of
court.
1 crore, my lord.
So read that part.
My lord.
What is the evidence on the basis whereof this finding has been given?
My lord.
Read the findings whereby Joel Carlos has been convicted.
My lord, as far as
Yes.
kindly come to my lord, the impugned judgment.
Yes.
At, page 1995.
Paragraph,
My lord. Paragraph 168.
yes.
Thus, it appears that there is an ample corroboration in the versions of the above 3 witnesses as regard the arrest of accused A1 and A2 and recovery of the incriminating articles, especially the 3 DSD blank letterheads. The learned counsel for the accused submitted during argument that such type of letterheads can be prepared by anybody, but the said submissions fail to impress us inasmuch as the circumstances under which the articles were recovered and the unacceptable explanation they offered for the possession of the same speaks otherwise. Now, this particular your letterheads, your lordship, this particular aspect is reduced by the trial court as a recapitulated as an intimidating factor in the evidences and has quoted at page 2 to 2004, my lord. As one page 2004, para 189.
Yes.
The role played by the accused can be recapitulated as under. Kindly come to serial number 13, my lord. The 3 blank letterheads of DSDJ have been recovered from the possession of Pojendra Hozai on 149 while he was carrying 1 crore to Shillong. Where the witnesses, your lordship, the witnesses have deposed as far as the punch witnesses, your lordship. Their statements were recorded before the trial court, before the magistrate in the 164, my lord. They come to the court in the dock and they say that as far as the recovery and arrest of us, we persons were concerned, it has been done in Borapani. That is almost 20-30 miles away from the place where they have shown. The prosecution does not declare hostile. This aspect was been prosecutor does not declare hostile, and this aspect was been verified from the chief IO. The chief investigating officer Mukesh Singh says that yes, I accept what these 2 witnesses have said as far as their apprehending is concerned by the Assam police. But the learned trial court, what they did is that learned trial court posed away that particular evidence and says that since Bunu Sonar and Dipankar Deka were the drivers of Babul Camper and Pojendra Huzai, their evidence goes away, and since these are a police persons, their evidence sticks. Your lordship will kindly see that aspect starts in page 1890, my lord. 1890. May I read it, your lordship?
You first read that evidence or the statement of that witness.
My lord.
who gives out evidence of some conviction that Joel Garlosa is the chairman or the person in charge of DSDJ? Who says so?
My lord.
Other than that, accomplice. Forget the accomplice for the moment.
My lord.
Who is the other witness? Or rather, read the finding of the trial court. Wherein the trial court says that this gentleman is the operator who runs this organization.
My lord, it is as far as the finding PW 20, the court is referring.
PW 20. Who is he?
PW 20.
Yes. Where is the statement? Let us see.
PW 20, evidence PW 20. Your lordship will paperbook volume 1.
PW 20.
PW
Yes.
20.
Read. What does he say?
Today I have, your lordship is there?
Hmm.
Today I have appeared before the court on receipt of the summons from the court. I was a cadre of DSD of NC Hills for about 16 years. From the year 1996, Joel Garlosa was the chairman, Dilip Nunisa was the vice chairman, and Pranit Nunisa was the commander-in-chief.
Yes.
From 1/3/2003, DSD group entered into ceasefire with the government.
Yes.
After ceasefire, Joel Garlosa continued with the organization. He suddenly disappeared. We do not know where Joel Garlosa went thereafter. We
Yes.
thereafter made Dilip Nunisa as our chairman to continue our organization until this stage. The said group worked and finalized the accord in October 2012. Joel Garlosa group also were the party to sign the accord along with us. After that, he was been declared hostile, my lord.
Yes.
So, your lordship,
Yes.
then kindly come to PW 23. Before we go to PW 23,
Kulendra. Yes.
my lord, before we go to PW 23, the lordship may kindly see the cross-examination of PW 20, my lord.
20. Conducted on your behalf. Jewel and
Jewel
Niranjan.
and Niranjan both.
Yes.
I was called to the DGP office, Ulubari, in connection with this case. I cannot remember who called me to the DGP office, Ulubari. I was not read over and explained into Assamese the statements which I have been shown today on the relevant day of my visit to the visit the office. In my presence, the statements which have been shown to me today was not taken down in writing. I do not know English language. I belong to the Dilip Nunisa group of DSD. After ceasefire, whether Joel Garlosa ran any organization or not, I do not know. I also do not know the names of the organization who were operating in the NC Hills district, state of Manipur, Meghalaya, and Nagaland, shares its borders with the district of NC Hills district. These three states also have many organizations, and there is possibility that organizations from these districts may cause illegal activities in the district of NC Hills. After ceasefire, I, along with others, used to stay in the designated camp. I cannot say whether Joel Garlosa was the chairman or the president of the organization. It is not a fact that Joel Garlosa was not associated with DSD.
Okay.
Now, my lord, PW 23.
Kulendra.
My lord. Kulendo Dolagafu. In the year 2002, I was a member of National Commission for Youth, Government of India. I resigned from that membership in 2004 and joined in active politics. I contested unsuccessfully from 16 Hapalong LSC in the year 2006. Again, I contested in MSc election in 2007 and won and elected to the NC Hills.
But he has nothing to do with Joel Garlosa. Why are you reading him? He doesn't even name him in the statement.
No, my lord. In evidence, he does, lordship. No, but the trial court records his finding of PW 23 as if the Kolendo Dalagopa has stated this thing from his own experience, but it was rather a hearsay. My lord, if you see the para 172
Yes.
of the impugned judgment,
Yes.
PWD Kolendo Dalagopa, an executive member of DSSC, testified that he came to know about the activities of GSD, about demand of money and violent activities they took.
During 2008, ASDC and BJP alliance was in power. During one of the meeting, Depolal Hojai CM Taisek is Hill and resigned as CM. Mohit Ujai was elected as CM. He went with Mohit Ujai to Kuala Lumpur in February, March 2009. At Kuala Lumpur, he met Niranjan Hojai. He stated that he gave statement under section 164 and exhibit 56 is the statement. Now, your lordship will kindly see his evidence,
We have read that.
my lord.
He doesn't take the name of Joel
Joel
Garlosa.
No. But a learned trial court brought in this.
Okay. So these are the only two witnesses who say about DSDJ and its connection, Joel Garlosa's connection with DSDJ.
My lord.
Who else?
My lord, there are other two witnesses were there.
Who are those?
That your lordship will kindly see. PW 24.
Yes.
Your lordship will kindly see the finding at 173.
Yes. Read.
Amitabh Sinha testified in the year 2009. He was additional SP headquarters at NC Hills and he was responsible for maintaining law and order. There was spurt of violence because of DSDJ, due to which train service flying from Lamding to Badapur was stopped. Thus, food grain going to Barak Valley, Mizoram, Tripura and Manipur was stopped. DSDJ group has resorted to firing on moving train. His evidence further reveals that because of counterinsurgency operation, laying down of arms by DSDJ cadres in March, April 2010 took place, but there was apprehension that all the arms and ammunition of DSDJ were not handed over at the time of laying down of arms. And on 8/7/2010, on receiving information, the arms and ammunition were kept in hidden jungle. He conducted search at Disakan area. He was accompanied by OC Haplong, and on search, they could find several gunny bags.
Judgment is referring. Yes.
Containing sophisticated weapons, including AK-47,
74. Para 170. Yes.
M16 pistols, liquid gun, as well as M21 rifles. And in connection with the same, the OC Haplong lost FIR, upon which a case numbers 54 of 2010 was registered. Exhibit 29 is the photocopy of seizure list containing 44 numbers of weapons and 41 assorted magazines and sale. PW 24 has also testified that by letter dated 16/7/10, exhibit 60, he sent to the SP NIA the FIR seizure list, and by his letter dated 3/9/10, exhibit 61, he informed the status of Umrangsu PS case number 18 of 2000 that both the cases were charged against Poinen Nightingale, Tangung Hansu, who are DSD cadres, and in the second case, 18 of 2000, Anul Panglo Mondeng Langtasa and absconding accused Peter Langtasa, Biren Singh Langtasa, Tanjan Hapila, Azairam Nunisa, and Ajit Khausan, all are DSD cadres. Cross-examination of this witness could elicit nothing tangible to discredit his version, except that he did not state before the IO about some of the facts about the law and order situation in NC Hills. He denied the defense suggestion that the arms and ammunition were not belonging to DSDJ. It is to be noted here that he categorically stated that he was responsible for maintaining law and order in NC Hills, being posted at additional SP headquarters. Therefore, the omission though may amount to contradiction, yet the same fails to cast any doubt about the veracity of his person. The law and order situation in NC Hills at the 11th point of time is apparent from the evidence of then Chief Executive Member Mr. Dipulal Hujai, 126, who testified that many efficient government officials were reluctantly posted at NC Hill because of extremists for which development work suffered. There was two groups of extremists, DSD and other DSD-J, and there was killing and kidnapping. But here also, your lordship, the learned trial court does not say to the effect that PW 24 has implicated Joel Garlosa in any way, in any matter.
Yes, carry on, carry on.
My lord, as far as my arrest was concerned, PW 26, the learned trial court referred to PW 26, Sudhakar Singh. As far as my apprehension is concerned, I was apprehended from Bangalore. That I'm not denying, my lord. I was arrested. I'm not denying also, my lord. Now, your lordship will kindly see.
Yes.
Kindly come to page one, para 176.
Yes.
The learned trial court records that Peterson made it testify that he was working as consulting editor of NETV. In the year 2008, any news telecast a story on Niranjan Hodai of DSDJ's chief. A video clipping was supplied to NI. Material Exhibit 15 is a said CD containing the voice of Niranjan Hodai. Again, news of Pojendra Hodai and Babul Kemprai was telecasted on 2429, a CD of which was supplied to NI. Material Exhibit 16 is a CD containing a news item regarding the recovery of 1 crore and other materials from the said 2%. The Lordship can kindly come to PW 27.
Part 2 and 3. Part 2 and 3 then. V1, part 2 and 3. Yes. Carry on, carry on. Yes. Volume 1, part 2 and 3. Yes.
The Lordship PW 27, page 140.
Yes. Statement of witnesses. Volume 2 again. Statement. Yes.
Today I have appeared before the court on receipt of the summons from the court. In the year 2009,
yes,
I was working as consulting editor of
the
NETV.
next one. Yes.
Prior to that, I was working with Doordarshan as director news and retired in the year 2003. I joined in NETV in 2004 and worked there till March 2013. In the year 2008, Northeast News telecasted a story on Niranjan Hodai of DSG chief, a video clipping of which was supplied to NIA at their request. Material Exhibit 15 is the said CD containing the voice of Niranjan Hodai. Again, a story on Pojendra Hodai and Babul Kemprai was telecasted on April 2, 2009, a CD of which was also supplied to NIA at their request. Material Exhibit 16 is the said CD containing a news item regarding recovery of 1 crore and other articles from the state 2%. My lord, he was cross-examined by Niranjan Hodai, my lord. Consulting editor is supposed to advise the editor-in-chief of NETV regarding contents of news and related items. I cannot say on which date the news of Material Exhibit 15 was telecast in NETV. The recording regarding Material Exhibit 15 and Material Exhibit 16 were not done by me but by my reporter, who have only supplied on the request of NIA the 2 CDs, but the said 2 CDs were never seized by the NIA from me. At the time of supply of the said 2 CDs, I have not issued any certificate regarding the authenticity of 2 CDs, Material Exhibit 15 and Material 16. The NIA officials also have not taken from me any certificate, or also I have not supplied any certificate regarding identifying the electronic records containing the statements and the description in the manner in which it was produced. I have also not issued any certificate giving particulars of the device involved in the production of those 2 said CDs. The NIA officials also have not seized any computer used for the production of the 2 CDs mentioned above. Then NIA officials also have not taken any certificate from any responsible official holding a position in NETV in relation to the operation of the relevant device or the management of the relevant activities in preparation of the 2 CDs mentioned above. Material Exhibit 15 and Material Exhibit 16 does not bear my signature. It is not a fact that Material Exhibit 15 and 16 were not supplied by me to the NIA, as because no such news clippings contained in Material 15 and 16 were telecasted in NETV. I am not familiar with the voice of Niranjan Hodai, so the voice clipping contained Material Exhibit 15 may be or may not be of Niranjan Hodai.
News reporting, what is evidence? Yes.
The Lordship, as the Lordship was putting a query on respect to terrorist activities with me, my lord.
Yes.
And the charge that was been framed under section 16, my lord. Though I will take it around, my lord, all the evidences, but it's a fact which has come up that there was no investigation with respect to any terrorist activities or terrorist incident was carried out
by the NIA in this case. And that comes none from anyone else but from the investigating officers themselves. So when the investigation, there was no investigation of any terror incident or terror activities, my lord. Then obviously the conviction under section 16 fails because the ingredients of 15 does not come into play. My lord, as your lordship was putting out on the last occasion when I heard it from when your lordship, my senior, was arguing that terrorist incident of spread incident of whether dual girls are involved in any other incident or any other matter, whether it has been investigated or not. My lord, as far as EW 72 Anurag Thakur, he said he gave the information to the NIA on his documents that there were certain cases that have been registered against the cadres of DSD, DSDJ. In some cases, my name was being involved, Jewel Galusas, Niranjan Hujai. But all those cases were been disposed of, my lord. In evidence it has come. The recovery of arms, which was done by Amitabh Sinha, PW 24, which I have taken on record, I've shown your lordship. We let a defense witness comes and shows the record that it was already FR has been given in that matter. There is no case as such because it was written untraceable persons, my lord. So if those parts goes away, so how come this landed trial court, my lord, coming to the fact that the recovery of 8710 at Disakasin area, contestant sergeants recovered of AK-47 and the M16 pistol can be attributed to me. There's no tangible evidence to that.
Okay.
There's no tangible evidence, my lord. Now, there was a fact, there was an allegation in the charge sheet, my lord, that me, Niranjan Hujai, and even Valnal Chana, my lord, we went to abroad, Thailand, Nepal, for our furtherance of our common objective. And in pursuance to that, what happened, my lord, the NIA carried out the investigation. They sought information from the CBI, the Interpol wing. They're asking, giving all our details that whether, can you give the trace where these men have gone on those particular days? It doesn't come on evidence, my lord. They had exercise of the NIA and the CBI. They said we don't have any evidence to show that Jewel Galusa has gone on that particular day to Malaysia, Thailand. So that allegation that we traveled abroad to in furtherance of our common objective.
Whether his passport was seized?
No, it was seized.
There must be entry in that passport.
My lord.
Visa entry must be there, no?
My lord, the Interpol officer, I will take your lordship in that. Your lordship will find, my lord. The other factor what your lordship, the trial court found against me was the disclosure statement given by Arsinga Warisa to on 13/7/2009. And the trial court, when we objected, when he raised the in cross-examination to the investigating officer, that you are saying that you have recorded this disclosure statement, but on this particular day, you claim that he was in SOU in the police station in SOU. But the records, judicial records speaks something else. He said, no, I don't, whatever I have said, whatever disclosure statement is true. So put a suggestion to that effect. Now, to solidify that aspect, the chief investigating officer was put a query that did on that particular day or any day, did you or any one of your officers took Arsinga Warisa for police custody and all?
Doing a TikTok videos or what? You are referring to statement of this, that, he said so. Why don't you go in a sequence? Read the statement of the witness you want to refer.
My lord.
Criticize it there where the portion is coming.
My lord.
Disjointed arguments would not take you anywhere.
The lordship will kindly come.
You are hearing, Mr. Mishra? That is a systematic way in which to present the arguments. You are just going around in circles.
My lord.
You have given us a background. Now come to the hard evidence, read those statements, criticize the statements as you want to. The findings are there before us. You refer to each statement on which the trial court has relied upon and criticize those statements as you want to.
Yes, your lordship will kindly come to evidence of PW 146.
Yes.
PW 146.
All right.
Volume 3, my lord. Paper book, volume 3, page 686.
Yes. Volume 3. Yes. 686. Read.
In the instant
Swayam Prakash.
Shyam Prakash Paniman.
Yes.
In the instant case, I was assisting the CIO Sri Mukesh Singh, then Superintendent of Police in NIA. I was also Superintendent of Police during that point of time, that is 2009. This was the first case of NIA which was registered after the creation of NIA. During the investigation, I was assigned certain tasks related to investigation. I had undergone a training on computer-related documents handling at the NCRB, which covers courses on Microsoft, Windows, especially Microsoft Word, Excel, and Access. I have prepared a disclosure memo pertaining to accused Arsing the Warisa related to his 4 email IDs, that is dimahasau@yahoo.com with password Tomahawk, arsingda2009@readymail.com with password Rambo Staro, Dawa2009@yahoo.com with password Asring, and robertbrown@gmail.com with password Ambassador Air in presence of witnesses at SOU Police Station, Assam on 13/7/2009, Exhibit 117. Consequently, in the said disclosure memo, Exhibit 117.3 is my signature. All these emails were attempted to be opened on 24 August 2009 in New Delhi, in presence of independent witnesses, of which only one email ID of dimahasau@yahoo.com with password Tomahawk could be opened, and 8 emails sent to NDFB 2001 yahoo.com, Arsanga yahoo.com, and Arsinga 2009 readymail.com were found. During the entire process, it was ensured the data taken as printout from the computer was free from any virus and malware. The printouts of all these emails were taken. Because of the busy schedule of the investigation at NC Hills, the undersigned was not able to carry out the recovery memo exercise, and as soon as internet access was found and the recovery memo was carried out in accordance with the provision of Section 65 Evidence Act, albeit no separate 65B certificate was prepared in the process. Exhibit 421 is the recovery memo. 421, 421-2, 3 are my signature. Exhibit 422 in 9 are the printouts of the emails.
What has he said against Joel Garlosa?
My lord, he has said nothing against me.
Then why you are reading?
My lord, this evidence was relied by the trial court and brought me that it was me who has sent email to NDFB from this.
Okay, you read that finding then.
My lord.
Tomorrow, continue. We have another bench.
Letter number 1.
May it please your lordship.
Yes.
Item number 1 and 2 are review petitions, your lordship.
Yes.
Analogous. And very limited ground, your lordship, I am praying for consideration of a judgment of the apex court that perhaps due to oversight will not be.
Oh, wonderful. You go and make a complaint to Honorable Supreme Court
No,
that
lordship.
we did not consider the judgment cited by the
So
council.
perhaps due to
Can
oversight.
it be a ground of review, sir?
Lordship,
Tell us.
it was placed, your lordship.
Maybe you file an affidavit that you placed it and the court did not consider it. Challenge it in appeal. Can it be a ground of review, sir? Show us one judgment that a judgment cited was not considered. So please review your order.
It has an effect on the entire judgment.
Maybe.
Because it deals with the right to recover of
Yes.
the employer. your lordship.
Yes.
And there is a specific direction, and based upon that judgment, your lordship, railways themselves have passed a notification that I have annexed,
Maybe, sir,
lordship.
maybe.
Right to recover.
My lord,
Because-
I have received instruction in this regard, my lord. 2 weeks time maybe to be granted to file an.
Just hold on.
Admittedly, he's a great.
Just hold on,
Sorry.
sir. Read from your grounds of review that this judgment was cited and it was omitted. It was ignored. Read.
Lordship, may I read it from the petition, your lordship?
Read from your review petition. That's
Review
what we are
petition
saying. Review petition.
The grounds directly do not allege in
Then,
that manner.
we'll accept your oral
Lordship,
version
even the
as
first-
against the
first-
judgment of this court.
First ground, your lordship.
Yes, read.
For that, though there is a discussion and decision on the entitlement of the petitioner to claim traveling allowance, the aspect of right to recover of the
It's all right. It's a wrong decision. Subject matter of appeal.
lordship. And
You are saying your argument, Mr. Counsel, at the inception was that we cited a judgment, it was not considered.
lordship.
Read from your pleadings of your review petition.
For that, the honorable court did not consider the deduction being made by the railway administration is unauthorized in view of the clear direction of the honorable apex court reported in so and so, as well as in view of railway board's notification.
Yes.
dated so and so. And these were part of the record in the original writ petition as well as the OA,
What was a part of record?
this notification, your lordship. which
So,
contains-
all right. So what? Your argument is that judgment was ignored. Where is your pleading that we cited and it was ignored?
Judgment, including the notification as well, your lordship. The notification was very much annexed in the OA as well as the writ petition, your lordship. Because admittedly, even they have admitted, we are the grade
Yes.
3 employees, your lordship.
Yes.
And the honorable apex court has laid down certain guidelines under which
So you
condition.
go to the Supreme Court, challenge that order, sir. It's a wrong order passed by this court. Assume for a moment, then the remedy is,
Lordship, if it is curable here.
no, can't be done. Here, you are asking us to take a totally different view.
Not, I am not claiming.
Then
that
what?
any-
You want us to cause the recovery. We refuse to do that. Now you say that no, you review your order and take a different view. Sorry, sir, not done. Dismissed.
Item number 2 is also
Same.
similar, your lordship.
Yes, same.
Item number 3.
Lordship, this review has been preferred by the Union of India, Lordship. What happened, Lordship? Here, the opposite party was appointed on the basis of that he declared to be a scheduled tribe of Arunachal Pradesh. The post plus mean for the 10 post plus means for the state of Arunachal Pradesh. Now, when we went for verification, the deputy commissioner wrote that the Deori community does not belong to the state of Arunachal Pradesh. Then we draw a departmental proceeding and finally we dismissed him from service. He went for an appeal, that departmental appeal also rejected. Finally, he challenged that order before the High Court. High Court held that since that the caste certificate has not been dealt by the High Power Committee as declared in the Madhuri Patil's case. So
yes.
writ petition was allowed, but that part is kept open. We went for a challenge that order of the single judge in before the division bench. Division bench also upheld, but gave a direction that his caste certificate has to be dealt by the High Power Committee.
Yes, then
Now
what?
his caste certificate has been cancelled, Lordship. So we are only to the extent that
It has been cancelled.
cancelled, Lordship.
So then you have been given liberty to take a decision.
Lordship, the back wages part, Lordship. We are only on the back wages part, Lordship. 50%
What he was working on what post?
Constable, Lordship. Now he has challenged that finding of the High Power Committee in a separate writ petition that is pending. Now,
Already.
Lordship may just modify to the extent that depend on the outcome of that writ petition, Lordship. That can let him appear.
We'll have to
Lordship.
hear,
Other side-
we'll have
let
to
the
hear.
other side appear, Lordship.
Issue notice to the respondent.
Lordship.
steps for service be taken in 3 days.
Lordship.
Rule is made returnable in. Counsel for the appellant, a petitioner is permitted to effect service by
Dusty also.
providing by the state.
Lordship. Item number
Returnable
four-
4 weeks. Yes.
Item number for Lordship is out of, the lunch CGC is out of station. So
Okay.
can we adjourn for the day, Lordship?
There is a specially constituted bench.
Lordship, that's the.
It stated that Mrs. Ega and counsel, standing counsel is not available today. The matter is thus adjourned.